passed legislation to ensure public trust and to reassure district employees that sexual harassment will not be tolerated in the workplace by requiring an independent review of the investigation. The Inspector General contracted with Arnold and Porter to produce the independent review my legislation required. Last month, the final report was delivered, and subsequently a redacted version was made public by counsel, which brings us to today. I've been asked why we need this roundtable. Haven't we done enough oversight? Well, my answer is legislative oversight is a continuous task, and this roundtable is a part of the council's role to conduct oversight of executive agencies. We also have a report from the independent investigator, which sheds light on the mistakes that were made, delivers new information, and provides recommendations for the future. I do want to emphasize the report's details regarding mistakes made by MOLC. These include misleading the public, failing to acquire and collect all relevant evidence, including electronic devices, not providing the investigation with the proper staff and financial resources, and neglecting to consider the need to consult with or refer the matter to law enforcement. Our goal here today is to dive into these serious critiques and identify where things went wrong and ensure the DC government improves going forward. It's crucial to create an environment where district government employees feel confident coming forward with complaints of sexual harassment, knowing that they will be taken seriously, handled with care, and that action will be taken. In this hearing, and the testimonies we hear today will also inform upcoming legislation, one introduced by me and another by Councilmember Bonds, allowing us to incorporate important lessons from this case. I'm committed to making sure that this report does not sit on a shelf and that we are setting a higher standard for the future. I'd like to briefly thank the attorneys here from Arnold and Porter, the firm that conducted the independent investigation and drafted the report. And thank you to the Office of the Inspector General and Mayor's Office of Legal Counsel for participating. I'm frustrated that the DC Department of Human Resources declined our request to participate. The committee is seeking answers from the pre-hearing questions sent to the agency regarding shocking information revealed in the report. For instance, I want to know how long DCHR has been without a dedicated sexual harassment officer. Why did the agency instead contract with a former MPD employee who isn't trained in sexual harassment complaints to do this work? Why was there an apparent lack of oversight by the agency in the sexual harassment officer process during the initial investigations? And when did DCHR last update their issuance guidelines before these complaints were filed? Today's hearing became even more consequential when we learned yesterday the Office of the Inspector General and the Mayor's Office of Legal Counsel have been rebuffing efforts by DC's Attorney General to hand over information as part of a criminal investigation into Valchecchio's conduct. To say this news is distressing is an extreme understatement. Why, after everything that has transpired, would MOLC refuse to hand over the investigative file to the Attorney General? How are we supposed to protect past and future victims and give them faith in this process? It's shameful. From the first news of the complaints, I have operated on the belief that our primary obligation is the victims in this case, as well as to all district government employees who should have unfailing trust in the process, but currently do not, and with good reason. Each step of the way, we have seen the executive branch take a fundamentally flawed approach, one that seems intent on protecting the predator, not the victims. A predator who is in the process of trying to rehabilitate himself in the same sphere of influence. The mayor didn't even follow her own order. According to the mayor's 2017 order, the Office of the City Administrator Sexual Harassment Officer was supposed to conduct the investigation. But the Office of the City Administrator didn't have a dedicated sexual harassment officer. The Office of the City Administrator said they used the sexual harassment officer at DCHR. But DCHR didn't have a sexual harassment officer and instead had a contractor who isn't even a government employee. It was then decided that the Mayor's Office of Legal Counsel should conduct the investigation, even though there were concerns about the appearance of bias. To make matters worse, the executive then decided to release the report literally in the middle of the night. Now it turns out the Mayor's Office of Legal Counsel is withholding evidence from an ongoing criminal investigation. Who does the Mayor's Office of Legal Counsel work for? How can victims trust this process? How can district employees believe their employer will keep them safe? In a news report yesterday, the Deputy Director of the Mayor's Office of Legal Counsel reportedly expressed concern that sharing documents with the Office of the Attorney General would, quote, chill the participation of witnesses and complainants in the sexual harassment process, unquote, moving forward. Seriously? The chill among Executive Office of the Mayor's employees already existed, as documented clearly and extensively in the report. The real chill comes from the leaks, reports released in the middle of the night, and an expectation that nobody will act on complaints when they're brought forward. I should think that sharing information with a law enforcement agency such as the Office of the Attorney General would be welcome and send a positive signal to employees, as it would indicate that finally somebody is doing something. The government should care about holding accountable the guy who did this to our employees. I'm not alone in questioning this. In fact, the report commissioned by the Office of the Inspector General speaks to this directly, and I quote, "While confidentiality of a complainant can be imperative to an investigation and to a complainant's well-being, the investigator should be wary of maintaining such confidentiality to the detriment of an accurate, well-resourced, and when necessary, cross-agency investigation." As frustrated and angry, to be honest, as I am about some of what transpired after the news of the complaints were made public, our focus today must be on the future, ensuring that district government employees have confidence in the process. I will now like to provide some logistical announcements for today's hearing. This hearing is being live streamed at briannecanedo.com/live. There are only three public witnesses, three public witnesses, and the rest are government witnesses. If you're having trouble watching this hearing online, you can reach my team at 202-741-2111 or by emailing publicworks@dccouncil.gov, and they will try to resolve your issue. Now let's turn to our first panel of witnesses. This is the panel of the independent counsel. When I call your name, if you could come to the table or turn on your camera if you're on the Zoom. Ms. Deborah Curtis, lead attorney, Arnold and Porter. Ms. Elizabeth Carney, associate attorney, Arnold and Porter. Mr. Josh Alloway, associate attorney, Arnold and Porter. Thank you. We're swearing. Okay. It is. Actually, yes, if you could please raise your right hand, both in person and virtually. Great. Do you swear or affirm under penalty of perjury that the testimony you're about to give to the Committee on Public Works and Operations is the truth, the whole truth, and nothing but the truth? You want me to call everybody now? I'll put them all at the table. Okay. I'm actually going to also bring up at the same time our government witnesses, Mr. Daniel Lucas, Inspector General, Office of the Inspector General, and Vanessa Natale, Deputy Director of the Mayor's Office of Legal Counsel. And we'll just go ahead and do that same exercise for you. You swear or affirm under penalty of perjury the testimony you're about to give to the Committee on the Public Works and Operations is the truth, the whole truth, but nothing but the truth. Thank you. Everyone may be seated. Thank you. All right, so we'll begin with questions for Arnold and Porter. Thank you, Ms. Curtis. Before we begin, can you state your job title and tell us a bit about what you do? Yeah.
There we go. Thank you.
Oh, opening statements. Sorry. We're going to allow anybody who wishes to do so to have an opening statement when it is their turn to testify. So we'll begin with you, Ms. Curtis. We'll do your questions, and then we'll go to our government partners. If you have any other colleagues who will make opening statements, they can do them following you.
Thank you. My name is Deborah Curtis. I'm a partner at the law firm of Arnold and Porter, where I serve in the white collar defense and investigations practice. I previously served more than 30 years with the federal government, advising on matters like sexual assault and sexual harassment, and conducting investigations both as a federal prosecutor and with different government agencies. I would like to introduce my team here today. Alongside me is Associate Lawyer Elizabeth Carney, also in the white collar defense and investigations practice. through Zoom because he is unfortunately out of the country is Josh Alloy. He is the head of our labor and employment practice in Washington, D.C. We also have Sam Witten, who is one of our attorneys in our international practice and a very seasoned lawyer for the federal government advising on government investigations.
Thank you. Will Mr. Witten be answering any questions, do you think?
I don't believe so, but it's possible. We should probably swear him in just in case.
Okay, Mr. Witten, could you please raise your right hand? Do you swear or affirm under penalty of perjury the testimony you're about to give to the Committee on Public Works and Operations is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you very much. Ms. Curtis.
Thank you.
You may begin your testimony.
Good morning. And thank you to Councilmember Nadeau for this opportunity to testify on a matter that is critically important to our city. My prepared testimony today will encapsulate our work, findings, and recommendations, and I will attempt to keep my introductory remarks brief so as to allow adequate time for questions. I also truly appreciate the council members' emphasis both on transparency and confidentiality, including by releasing a redacted version of our report, which I will avoid rehashing in detail. Arnold & Porter was retained by the Office of the Inspector General for the District of Columbia pursuant to the Sexual Harassment Investigation Review Emergency Act of 2023, which directed the Inspector General to hire and direct an independent counsel to first review investigations of complaints of sexual harassment and violation of Mayor's Order 2017-313 against Mr. John Falchecchio, the former Deputy Mayor for Planning and Economic Development and Chief of Staff to the Mayor of District of Columbia, to investigate other findings and items outside the scope of the prior investigations, and to review and make recommendations on sexual harassment complaint and investigation procedures for the district government. Throughout our work, we focused squarely on the fact that the council adopted this legislation in order to ensure public trust and give greater confidence to district employees that allegations of sexual harassment will be taken seriously and handled without influence. My team and I carried out this assignment with that critical objective in mind at all times, to work quietly, thoroughly, and with absolute integrity so that the council and the public would have confidence in both the outcome and integrity of our recommendations. To emphasize, this report was candid in providing an outside perspective on all aspects of the events as we observed them, including all of the individuals and offices involved. The situation we found during our investigation showed areas for improvement all around, as was made clear. This was the job requested and the result achieved. And of the hundreds of investigations I have overseen and conducted, this has been one of the most meaningful. Our work is entirely independent within the contours of the contract we had with the Inspector General's office, but we did have close consultation with OIG, including weekly scheduled meetings and more frequent consultations when necessary. Before I get into our findings, I wish to say a word about the women who came forward in this case. Of the utmost importance to the independent counsel team of Arnold & Porter was and continues to be to protect the honor and of the women who were brave enough to come forward with these allegations against Mr. Falchecchio. We note their absolute courage and fortitude, because without that, his activity might never have been revealed or addressed. Our job was not to reinvestigate the complaints, but we nonetheless confirmed their credibility in finding that they were sexually harassed and that Mr. Falchecchio engaged in significant misconduct that resulted in a negative impact in his workplaces. Nothing should shift the focus away from these very important findings, as the council member has stated. We made each of our findings by weighing all the evidence presented with an aim to be fair and neutral to all parties involved. And we had the privilege and opportunity to interact with these women, and we came away impressed by their strength, dignity, and candor. We wish to stress it's critical for us to ensure they're treated with great respect. On January 15th, 2024, Arnold
Arnold and Porter commenced a 3-phase review and investigation, and we delivered our final report to the Inspector General on May 10th, 2024. We're pleased to report today that as of the date of submission, we came in approximately $92,000 under budget. Turning to phase 1, this is the review of the 2 prior investigations conducted by the Mayor's Office of Legal Counsel. In our review, the independent counsel evaluated the actions of district officials across key decision points and tested the conduct of the MOLC's investigations against the rigors not only of the mayor's order, but other district laws and policies, as well as best practices for internal investigation. Those include maintaining independence from actual or apparent conflicts of interest, complying with the law, maintaining confidentiality, ensuring fairness, diligently working to meet the needs of the investigation, and conducting the investigation competently with adequate staffing and appropriately trained personnel, a well-scoped investigation, and proper handling of witnesses, records, and sound conclusions. Again, given our mandate, we did not undertake a complete full reinvestigation of the complainant's accounts of sexual harassment. After reviewing the original transcripts from the MOLC's investigations and other evidence, which included extensive detail, we determined that we did not want to take any steps that would unnecessarily risk re-traumatizing the complainants. We did, however, interview complainants 1 and 2 on matters we deemed relevant to our review, including the conduct and comprehensiveness of the MOLC investigation itself and the effects of certain actions by DC government officials related to the investigation, including the release of the summary findings. We appreciate the cooperation of the numerous government officials in the DC government who provided us with this information and enabled us to develop a robust factual record. Our factual record included reviewing 45 interview transcripts, DC agency records, social media posts, photographs, emails, text messages, in total, approximately 350,000 documents. We interviewed 7 individuals involved in or familiar with the investigation, and we took statements from other DC government officials concerning their familiarity with the investigations. We also sought and received guidance from subject matter experts within the Office of Inspector General about how to interpret certain policy regulations. Our findings in phase 1. First, the MOLC's conclusions that Mr. Falcicchio committed acts of sexual harassment against 2 subordinates were well-grounded in fact and law. Second, the MOLC acted with integrity and professionalism in conducting the investigations. Third, we encountered no indication that the mayor or any of her senior staff tried to improperly influence the conduct, scope, or findings of the MOLC investigation. Fourth, consideration should absolutely have been given about whether the investigation would be more appropriately or efficiently handled by an independent investigator or by other DC government entities or law enforcement. Fifth, certain aspects of the MOLC investigation could have been better handled to ensure that the process not only fully complied with the mayor's order and best practices for independent investigations, but that it appeared that way to the complainants and the public. That the decisions the MOLC made in scoping, structuring, and resourcing the investigations were more practical and appropriate under the circumstances, and that prompt referral to or assistance from other district government agencies or law enforcement was more actively sought or considered, including a referral to law enforcement as we have done here. 6, that the mayor's order did not adequately delineate which agency should be responsible for receiving and handling a complaint against someone who was dual-hatted, like Mr. Falcicchio. 7th, that the combined effect of various public statements was to create the unfulfilled expectation by the council and the district that the district would be conducting a much broader investigation. And finally, that the public release of the findings of the first MOLC investigation over the Juneteenth holiday weekend was demoralizing to the complainant and misleading to the public, as the council member has noted. In particular, our report criticized press conferences that were handled by the MOLC. The fact that the public release was not contemplated in the mayor's order, but had actually, and went against the complainant's specific requests to keep their findings confidential. That the district failed to provide the complainant with advance notice of the public release. And that most importantly, the report found that the form and content of the release was, as I said, demoralizing to the complainant and misleading to the public, and was one of the most significant missteps. Turning to phase 2, we undertook our own independent investigation about matters that had been determined to be outside the scope, but had been raised within the conduct of the MOLC's 2 investigations. We worked in close consultation with the Office of Inspector General in order to resolve the following 4 questions. Whether Mr. Falchecchio used his position of power to influence sexual attraction-based hiring decisions in the district. Whether Mr. Falchecchio used his position of power to reward individuals with favorable personnel actions, like promotions, for engaging in sexual conduct with him, or for staying silent about his sexual related behavior. Whether Mr. Falchecchio used his position of power to cause retaliatory personnel actions, like demotions, against district employees who rebuffed his sexual advances, and whether Mr. Falchecchio dated or attempted to date subordinates within the Executive Office of the Mayor or the Office of the Deputy Mayor for Planning and Economic Development. We also reviewed the MOLC's decision not to investigate allegations against Mr. Falchecchio that had been brought forward by a member of the public. During our investigation, we interviewed and attempted to interview numerous individuals with information we judged to be relevant to the above questions. We sought and received and evaluated district records and statistical data, and where appropriate, we credited and relied upon the factual record, which was well-developed from the MOLC investigations, and concentrated our investigative resources on areas that had not been investigated, such as hiring and promotion practices. In sum, our findings are based on facts we found to be credible and as well-developed as possible under the circumstances. I will note that our authority to investigate was granted through the contract with the Office of Inspector General, and we had no power to compel the production of documents or witness testimony outside the control of the DC government. A further note about our scope on the issue of workplace climate. While we note in our report that our team did not undertake a full-scale climate assessment of the workplace, because that would involve an extensive multi-month process, including surveys covering every aspect of employee well-being and attitudes charted over time horizontally across the organization. I will note we think that's a good idea to do. But given our understanding of both our contractual obligations and the OIG's direction, and in keeping with the time strictures we had, we instead undertook a targeted climate assessment focused on the fallout from Mr. Falchecchio's conduct. Our findings for phase 2, our independent investigation, that Mr. Falchecchio committed acts of sexual harassment against the 2 employee complainants as found by MOLC, and likely committed acts of sexual harassment against a 3rd subordinate who did not come forward. Many of the steps Mr. Falchecchio took to try to initiate sexual relations with these women were strikingly similar and strongly suggest that he had a modus operandi. Second, Mr. Falchecchio engaged in a consensual romantic relationship with another subordinate on and off for an extended period of time. Third, that we found no other formal complaints of sexual harassment against or sexual harassment related investigations into Mr. Falchecchio prior to the 2 women coming forward in 2023. We found no dispositive evidence that Mr. Falchecchio orchestrated the hiring or promotion of individuals based on his sexual attraction to them, or that he caused formal, beneficial, or retaliatory official personnel actions to occur based on whether those individuals, including the complainants, accepted or tolerated his sexual advances. Fifth, we found that Mr. Falchecchio did show favoritism towards certain employees, including some female subordinates, and that this attention or lack thereof contributed to workplace tension, caused inter-office disputes and grievances to erupt amongst his subordinates, having a toxic effect on the workplace environment, including the appearance that he may have affected personnel actions based on that favoritism. And finally, we found that the MOLC appropriately declined to investigate under Mayor's Order 2017-313 the allegations of inappropriate conduct that arose by a third member of the public who was neither an employee nor a DC government contractor at that time. And finally, quickly through phase 3, our recommendations for changes to the process. In making the recommendations that followed, we weighed the investigative shortfalls and public misperceptions we identified in our phase 1, our review, as well as the systemic concerns and issues identified during our own independent investigation. We also considered that the district had issued a new Mayor's Order 2023-131, which superseded the old order and addresses some, but not all of the issues we identified. Finally, we consulted with relevant officials in several other major cities and took into account the sexual harassment complaint and investigation policies and procedures of Baltimore, Boston, Chicago, New Orleans, and Philadelphia. Number 1, we recommend that the district consider establishing a centralized oversight panel that would screen complaints and, where appropriate, assign experienced investigators to guide and assure that processes are followed consistently and competently. The oversight panel would also ensure cooperation and appropriate information sharing across agencies in the DC government. 2, the district should enhance training for designated sexual harassment officers. Those officers' duties must be clearly delineated, and they should receive ongoing, enhanced, interactive training and materials on issues such as developing an effective investigation plan, evidence collection, the standard of proof, identification of allegations, scoping of investigations, interaction with private counsel attorneys, and laws governing privacy and confidentiality. The district should also consider identifying a cadre of specially trained super sexual harassment officers who could deploy from their agencies to manage particularly complex, unusually sensitive, or very large investigations. The district should issue guidelines for crimes reporting and name a law enforcement liaison, because the line between sexual harassment and criminal activity is sometimes unclear, or additional facts may emerge during an investigation. We recommend issuing guidance that at a minimum would assist in the identification of potential criminal activity and signal when an immediate consult with an agency, general counsel, or law enforcement is important. That the district provide complainants with additional information. It would be a high priority, as we learned from talking to the complainants in this case, to ensure that whenever anyone makes sexual harassment allegations, they know about all of the concurrent and alternative options that are available to address their concerns. That the district develop a policy governing the public release of information and clear guidelines on when and under what circumstances a confidential sexual harassment investigation's findings may be publicly disclosed. 6, that the district establish a streamlined contractual mechanism for independent investigation. Time is of the essence in any investigation, and the district should consider establishing an expedited process to contract for independent investigators. Finally, that the district consider opening an anonymous tip line or email box that would provide another safe avenue for a complainant and could serve as a useful indicator or starting endpoint from an investigation. In closing, the Independent Counsel would again like to thank Councilmember Nadeau for the opportunity to present our findings to you and to answer any questions you may have.
Thank you very much for your testimony. You told us a little bit about yourself earlier. Can you talk more specifically about your experience with sexual harassment investigation?
Absolutely. So beginning when I was working as an Air Force JAG officer, one of my roles at the U.S. Air Force Academy was both as a prosecutor and what was called cadet counsel for active duty officers and cadets at the Air Force Academy who may have suffered either sexual harassment or sexual assault. So I had daily interaction and contact not only with individuals who suffered and survived assaults and harassment, but also with the structure of the Air Force Academy and the leadership to try to make changes there. I was brought back after I left the Air Force and was in the Department of Justice by the Secretary of the Air Force to serve on a Tiger team, they called it. And I was the only lawyer on that team. Once there had been public accusations of widespread rape, sexual harassment, and gender discrimination at the academy, to come back and try to get to the bottom of it. So I spent months at the Air Force Academy interviewing cadets and drafting up not only policies, but having focus groups and other predictors to prevent that to happening. I'd like to say that the Air Force Academy, of all service academies, is trying to be a model based on that, the Secretary of the Air Force's push. As a federal prosecutor, I was involved in all manner of cases, certainly general crimes involving sexual assault cases. And when I was most recently at the Central Intelligence Agency as the Deputy General Counsel for Litigation and Investigations, I had the opportunity not only to help reshape the CIA's process for handling these serious matters internally, which is an extremely tricky endeavor given concerns about individuals' cover, being concerned about going forward to law enforcement and losing their job because they tell their true name. It was one of the most challenging and gut-wrenching experiences I have had, but working with a very motivated leadership at CIA to try to make it work. I then was in charge of the CIA's response to an investigation of that process brought forward by some women who went to the House Permanent Select Committee on Intelligence. And I worked with the HPSI, they're known as, staffers, to give them information to help them shape a change for whistleblowers and sexual harassment and sexual assault at the CIA.
Thank you for your service. And it's incredibly impressive, the work that you've done at the federal level. Was this your first opportunity to work on a DC government case?
It was. And when I saw the request for proposals, I immediately knew that this is something for a city that we love that I should go for. And so I'm very proud to have participated in this.
Have you ever worked with any other local governments?
I have worked with many local governments in other areas. I've worked with the city of San Diego when I was an assistant U.S. attorney there working on border crimes. I have worked with the city of Colorado Springs when I was at the Air Force Academy. I've also worked with multiple municipalities in Virginia when I was at the CIA. Certainly, we wouldn't be involved in the cases I worked at when I was at the Justice Department here in Washington, dealt mostly with national security matters, but we would have many joint task force where we would work with law enforcement and other agencies, including inspectors general, on all matter of investigation and personnel actions, particularly when there was an insider threat.
Thank you very much. So I'm going to ask some questions about the contract deliverables. What date did the investigation begin?
The investigation began on January 15th.
And on what date did the investigation conclude?
On May, the entirety of our report concluded on May 10th when we delivered it.
The contract states that the council was required to meet on a weekly basis with OIG. Can you describe the content of what was discussed during those briefings?
Certainly at a very high level, we would give the OIG contracting official, who was our point of contact there, a PowerPoint each week. We would typically meet on a Wednesday. On Tuesday, 24 hours in advance, we would give essentially a status report and updates, both what happened the previous week and what we plan to do the week upcoming. So that was gathering evidence, interviewing witnesses, reviewing documents. We basically kept them informed at a meta level about everything we were doing and whether we were encountering any struggles or difficulties or needed a steer on, do you want us to go do this? Is this how you would like us to execute this particular term of the contract?
Were there any challenges, big or small, identified during these briefings?
Sure. I don't think I would characterize anything as a big challenge ever. One of the major challenges that we noted in our report, well, there were probably two that I would highlight. One of the issues we wanted to get to the bottom of was whether there had ever been any other complaints against Mr. Felchicchio. And we had to go about that. And I'll just put a pin in that for a second. That's sort of, this underlies one of the reasons why we think there should be a centralized cross-disciplinary office overseeing this. We had to go out in a patchwork manner to all of the different offices who might have had evidence of such a complaint. Now, that is not unusual in the government, in my experience at all, but we should be better and we should always strive to be better. So we couldn't tap any one institution or office in order to determine whether that was true. So we were, I wouldn't say we were fumbling around, but we were having to shoot out to every office that could have possibly had it, a request for, please give us this information. We got personnel records. People were not uncooperative, but we wanted to make sure we were canvassing the right offices. One of the major challenges was there was a statutory, and we note this in our report, for the Office of Human Rights, a statutory preclusion, at least our general counsel believed, for confirming or denying whether or not there had been a complaint. We raised this with the IG. They followed up as well. Eventually, we were at an impasse. We couldn't overcome the statutory objection, although we did feel like we got what we needed and were able to feel confident in our finding that there had not been additional complaints, because the Office of Human Rights would have had to refer that matter to one of his other offices, so there would be ancillary evidence of it. So that was one challenge we had. There were witnesses who were no longer employees of the government who were identified by our team as having salient, important probative evidence here. Those witnesses, some of those individuals did agree to come in and speak to us. So there were people either that the MOLC had identified and not talked to, and did not talk to the MOLC, or new people that we identified as we went along in our investigation. Some of them came forward, some of them didn't. There was one employee who is a current employee who did not make himself available for an interview. This was the subject of great discussion between us and the IG's office about what steps we could take to compel a current employee. Ultimately, the decision was made that we would not be permitted to exercise any compulsory authority, but that was weighed against sort of the importance of the testimony. This individual had talked to the MOLC show. This is the security detail officer. He's an MPD officer. He's obviously got duties that are critically important. He had given testimony to the MOLC show, although it was limited and in some cases we thought underdeveloped. And we wanted to interview him. While he did reply to certain of our requests, he ultimately did not come in for an interview. And so we were unable to get that. So I would characterize those as sort of the two sticky points we had. Everything else was really relatively smooth. We were able to, as I alluded to in my opening statement, we were able to go back to the IG's office and say, like, for example, we need to talk to someone in HR to explain to us what this means when someone gets a pay jump over a 6-month period. And we want to see, is that something significant? Is there something strange about that? So they were very responsive to our one-off requests, I would say. So there was nothing that I felt that, we were not getting the full cooperation of the IG. It was a very interactive relationship.
And just a follow-up question for Mr. Lucas on that. Why did Inspector General's office determine in consultation with counsel that you couldn't compel the current employee to come forward and testify?
In order to compel the employee to participate, I would have had to issue a subpoena. In my view, issuing that subpoena is not allowing the independent counsel to independently conduct their investigation. We also had to balance obtaining that information for their report And what I concluded was, based on what they got from the record, that they were able to draw the conclusions that they needed to make.
So, was there another way the contract could have been structured at the outset that would have given the legal counsel subpoena power so that you didn't feel you using it would be interfering in the independence?
Of course, that could have been part of the contract, but it wasn't.
Okay, yeah.
But again, I was mindful of allowing them to independently do their work.
Thank you. Ms. Curtis, can you explain the process for transferring ownership of the records to the OIG at the end of the contract period?
Sure. So as we worked through the confines and the provisions of the contract, we consulted with them about where records would be housed. We used a relativity database within Arnold and Porter that was cabined off from others. And so we have essentially the record copy that is owned by the Office of Inspector General. So we are at the ready to deliver within the bounds of the contract, wherever that record copy needs to go. So we have maintained that. And in fact, my associate here is in charge of that process. So it is not our property, but we are in custody of everything other than sort of the report and other information that they might have had from another source.
So you have a copy of everything that you gathered, and the Inspector General also has a copy of everything.
No, the Inspector General does not have a copy of everything we gathered. We are holding that on their behalf.
I see.
But again, we're not holding it. We will produce it whenever it's requested.
And the contract states that you were to provide 3 draft press releases for the Office of the Inspector General's use. Is that correct?
That's what the contract states, yes.
And the first was with the release of the investigative report. Did you submit that?
So we did not, and it became clear as we reported our findings and sort of at each milestone of the different 3 phases we came forward, and the guidance that we received, because we asked, do you want a press release now? Because we've completed phase 1, and they said it's, given that we didn't just do it in seriatim, because while we were talking to the complainants in phase 1, we were asking them about things in phase 3, for example, would it have been better if someone had done this? And so the Inspector General's guidance to us was, let's integrate this report fully so that we're not giving not a misleading, but just sort of a incomplete picture, because it became very clear that these 3 phases were inextricably intertwined, and you didn't want to talk about phase 1 if you weren't also going to cabin that with, here's how it should be fixed. Also, we wanted to make sure we had developed the record well in phase 2, because we didn't want to say anything that could be potentially misleading about what had happened in phase 1. So it became clear that while I think that was aspirational under the contract, and as conceived, we all thought that would be the best way to go. It really came down to, at the end, let's get this in an integrated package. And then essentially our executive summary was what we intended to be made, at their discretion, released. We didn't offer them PR services, but we did endeavor at all times in this report, understanding the criticality of transparency here under the statute, to attempt to make it as releasable, if that's a term, as possible. And so including taking out names of individuals who weren't already known, and trying as best we could to protect the confidentiality of the women who came forward.
Thank you. The contract required you to submit a summary report of all work completed suitable for public viewing within 90 days from the date of the award. Did you submit that?
So that we would consider our report and the executive summary to have fulfilled that obligation under the contract.
Okay.
We believe that that's suitable for public viewing. And in fact, we believe everything that the council member has released is appropriate for public viewing.
Did you believe that the report you submitted to the council was appropriate for public viewing or that it required more redacting?
We believe it required some more redaction. We made a note that we wanted to make sure we were able to be full-throated in it, but we took every possible step we could. But we also, we were concerned that there were things we didn't know, and we didn't want to fall into the same trap of saying this is good to release without someone else looking at it and saying you might be able to figure out who this individual is by a certain date or other things. So we only included those critical facts we thought needed to be included. And so, having reviewed what has been released, I believe the council member has done an absolutely appropriate job in protecting those facts that we felt needed to be in there.
Thanks for that. Were you asked to provide a redacted version?
We were not asked. By the
Okay.
way.
And Inspector General, you released the confidential report to the council and the mayor's office. Were you intending to do also a redacted version?
I was not. My obligation was to provide council and the mayor a complete report.
Okay. Did you believe that the version we received was suitable for public viewing?
Like independent counsel said, I thought it required additional review to make sure private information remained private and confidentiality remained confidential.
Thank you. Ms. Curtis, the contract required you to submit a report identifying recommendations on sexual harassment procedures of the DC government, which again would have been suitable for public viewing within 60 days from the date of the award. Did you submit that?
Yes, we did. That is phase 3 of our report.
Okay. And all of that was suitable for public viewing?
Yes.
Were you consulted regarding whether or not the version of the report should be released to the public?
We were asked, I believe, and I want to make sure I get this correct, we were asked whether we had an opinion or legal advice to give on that. And I think my law firm indicated we can't give legal advice on that issue. We consulted with the Inspector General's office and gave essentially a much more granular version of what I just related, which is there may be things about dates people were in certain offices. That was our main concern. We didn't want to give, especially for the individuals who are still working there, any kind of roadmap to someone who might be able to identify them. And so that was the advice I gave to our client, the Inspector General, to ensure that they could appreciate the same issue. We may have been over concerned, but I feel that we can't. It's hard to be over concerned when you're protecting. We were as scrupulous as we possibly could be to make sure the most could be released. And so that was truly it. And it was hard for us sort of from our vantage point to say whether a particular fact maybe had already been out. We just didn't want it. We didn't feel confident and we didn't want to put their lives at risk. I mean, their emotions.
Well, that was my approach too, which was what made it so challenging. We received it on a Friday and essentially had to hold it from the public until our attorneys had time to redact it, which they weren't necessarily expecting they would have to do. So it was incredibly challenging. What was your reaction when someone released the unredacted version to the media?
I thought that was a terrible travesty. Leaks are really some of the most damaging things that the government can do. And they're just irresponsible. There's a reason that things are kept. This wasn't a political report. This was independent and it was obvious to anyone who had it that it contained very sensitive details about people. So it was not as if this was a whistleblower saying, I'm going to show this to the world and then they're going to know. It can only hurt the individuals who are there. So it was not good. I might even recommend on the fly, my team will probably not like this for saying this, but I think future contracts should account for having a redacted version so that this process doesn't have to. I appreciate how hard it was because it would just be just as hard for us to have done.
Certainly.
Yeah.
And we were very cautious, in fact, in distributing even further than we received with like only hard copies. None of us, I mean, we were in the building on a Friday night, making sure that
Right.
nobody was emailing it. I'm not
Sorry.
complaining to you, but just in terms of the way that we were trying to keep it confidential, knowing that there was sensitive information in there, but also knowing that the council members themselves who voted to establish this investigation would want copies, right? So,
Absolutely.
and certainly they deserve to be able to see the full unredacted version. So it was certainly a challenging situation and one that I've never been in before and learned from.
Having dealt with redactions at the CIA, it's a onerous process, but a critically important one.
Yeah.
And to get as much out as possible and only withhold that which needs to be. So again, I would recommend that as this is being built next time, we used to call it red boxing in the CIA. You might
Mhm.
red box information within your report that would need to come out.
Oh,
And that might be a way to do it.
that's a good way to do it. Great, good suggestion. Thank you. Well, we hope to never be in this
I hope
position
never,
again, but.
I hope never, hopefully.
All right, some more housekeeping. Let's shift over and discuss the contract payments. The estimated price for the contract was $749,600. Is that correct?
That's correct.
And how much were you actually paid?
We were actually paid, hold on, let me get our
Take your time.
billable time. $655,100.
On March 16th, you were paid $87,077.80. Is that right?
That's. Okay, that sounds right to me. I signed off on all the bills, so that was roughly what we were running. We ran hot, as they say, and again, this billable thing is new for me.
Oh, that's
From the
okay.
government.
Right.
We-
Yep.
We ran hot while we used a lot of hours while we were writing and while we were investigating. And so that seems to be about right, given the months we worked.
Can you recall what portion of the work that first payment covered in March?
In March, that would have been the review, largely the review. And again, it's hard. I think at the time, as we embarked on this, we fully believe we could compartmentalize the 3 phases. But I would say it was the review and sort of the looking forward to phase 3, because we wanted to see what happened that was bad and wrong. Bad is the wrong word. That was, that could have been improved. And phase 1, and immediately start thinking and germinating ideas for phase 3. So including, asking questions of the complainants, asking questions of witnesses. So we integrated particularly phase 1 and phase 3, but also phase 2 also, because when we talked to the complainants, we wanted to know, for example, about the workplace climate and why they thought, why there was an impression that he was favoring certain employees over the others. So I would say it was that type of activity that was happening with a very high tempo in March. So that would have reflected that. And the way our law firm bills, it's for the previous month. So that would really have probably been for the February, early March timeframe.
So the next chunk was $269,387.40. That sound in the ballpark?
It does.
Okay, and that was April 6th. What did that portion?
That was
cover?
the writing.
Okay.
And that was very labor intensive. Extremely labor intensive, because we were integrating everything into the writing, and we wanted to be really careful and make sure that we were getting it, that we were giving it the detail and the neutrality that it deserved. And as you saw, it's a lengthy report. We thought about making it more succinct, but given its purpose, we thought it was important that we were detailed.
On May 7th, you were paid $113,710.30. Does that sound about
Yes.
correct? And what did that portion cover?
That would have been the compilation of the 3 phases. So we delivered and wrote phase 1 to the Inspector General. We presented on phase 1. And that was the time when we decided we were going to make this a single work and integrate it, because the 3 phases spoke to each other. And we wanted it to be comprehensible and readable, and not just in seriatim, on their own isolated bases. So we had to, the latter part of the report was integrating back in that which we had found in phase one, our new investigative, and then crystallizing the findings. So that was the bringing it all together phase. And again, that was highly labor intensive.
On May 21st, you were paid $99,141.85. Does that sound correct as
That
well?
sounds correct.
And what did that cover?
That was essentially the finalizations, the briefings, the polishing of the report. We worked all the time on this report. And so there was never a time this wasn't on our mind. And again, that was, I would say, polishing and drafting phase. We also got quite a bit of feedback on, being more expansive. The IG was very careful not to direct us anything about our findings, but we wanted feedback on how long do you want this to be? Because we can write for a long time on this. How detailed, how many other cities we thought we needed to talk to and consult with to make sure that we gave the district our very best advice. So I would say that's what we were doing at the end stage of this to make sure that it was polished and appropriate. We also went back, and this was quite labor intensive. We had originally included names, not of the complainants, but of all the other district employees. And that there was quite a bit of labor intensive work going back and making sure we had sanitized those names out. So that took a number of days toward the end. So I think it was, again, I would characterize that all as polishing. Sorry, that was an overly long answer to your question.
Helpful to understand the process. The final payment, June 7th, was $8,718. Sounds like that might have just been wrapping up.
Wrapping up.
Okay. Any additional payments due or to be made?
So we have obviously done additional work on this, including preparing for this hearing. I'm not certain whether, I understand speaking to the contract officer that anything that happened after May 10th because of the statute, we're probably not able to be paid for. So this is a labor of love.
Thank you for being here. Was there anything the Inspector General asked you to remove from the report before submitting the final copy to them?
I think in consultation with them, they recommended that we take out names of other, that was really it. I'm trying to recall if there are any other specific recommendations. That was really it. We were anticipating that the vast majority of it should be made public, that there was no need to essentially lay out the names of the general counsels of the various agencies and those types of things who we interviewed. So that was what I recall being sort of the ask at the end of the day.
Okay. In the report's appendix, pages 98 to 100, the report states you sought records from specific government agencies and received no responsive documents.
Yes.
What does no responsive documents mean in this context?
That means that they indicated that they had, that there was no evidence that those documents existed. So that wasn't a failure to respond, but that was an affirmative indication that there was nothing responsive to our requests.
The report shows that you received no responsive answer from every executive agency you requested information from. DEMPED, Executive Office of the Mayor, Mayor's Office of Talent Appointments, Office of Human Rights, and DCHR. Can you explain why you believe no responsive answers were received from the executive?
We sent detailed emails to them requesting, and I can read them to you if you like. Would you like me to read an example
please.
of one? All right, hang on. I'm gonna, maybe I'll turn it over to give my associate some experience. here.
Sure.
Why don't you start with Moto there, and then we can go to the OH one. So we're going to give you two examples of the email.
We sought the below records from the Director of Operations at MODA and received no responsive documents, and these are the requests. Any and all records of prior complaints or allegations of sexual harassment, hostile work environment, bullying, or retaliation involving John FAL TTO during his employment with the District of Columbia in any capacity. The request, we also specify that this request expressly included internal records and informal or formal complaints, such as through the EEO process, as well as any reports or communications to the Executive Office of the Mayor or Office of the Deputy Mayor for Planning and Economic Development. And we received no responsive document. The response was, we don't have documents responsive to your requests.
Which in layman's terms means that they have no record of anyone complaining before the complaints that we were investigating.
That's correct.
Okay. Can you detail any alternative steps you took to obtain the needed information, or let's say, to determine whether or not there were still concerns?
Absolutely. So in addition to canvassing every relevant office with these, they looked to me like what I would draft for subpoenas when I was prosecutor requests. We also asked witnesses, and we targeted, for lack of a better term, the witnesses who had been in either some sort of supervisory or human resources role in these various agencies, including as EEO counselors, and we brought them in, and they were very helpful to determine whether there was any indication that anyone had come in with a complaint against him before. It is, from my experience, these cases aren't usually isolated, and I felt very concerned that we get to the bottom of it as much as we could. We spoke to people who we credited their testimony, and they indicated that there had not been any complaints. Now one witness said to us, oh, they would complain about it, but it wasn't about sexual harassment. It was because of his personality or some other feature of it, but not sexual harassment related. So those were the other steps we took.
Now, Mr. Polchecchio had government issued electronics like a laptop and a cell phone, right?
Yes.
Would you agree with me that those devices may have contained pertinent information related to the investigation?
Yes.
You noted on page 35, footnote 66, that you don't know the exact date he turned in his devices due to an inconsistency, but they were eventually turned in, correct?
Yes. As far as we know.
Did you seek to resolve the inconsistency?
We did, and I think it was a matter, I'm not sure anyone could have resolved it because it was a matter of someone asked him to turn them in, and then someone else had them turned in. So we didn't know the mechanism, the means, the dates, but we know that eventually they were recovered. There also was, an indication because there were later Freedom of Information Act requests pertaining to those. So again, we had a mystery on our hands, and I'm not sure it would be solvable without a chain of custody for the documents. And I don't think anyone, and that's probably a good recommendation, is that you, again, apply law enforcement type tools to ensure you have positive control over things like electronics.
Mhm. And you mentioned, so he was asked to turn them in. Eventually, somebody had possession of them. Do you know who received them?
Yes, I believe it was the Office of Technology, and I'm forgetting the acronym right now.
The Office of the Chief Technology Officer?
That's it. Yeah,
Octo.
Octo. That's
And
right.
is it your understanding that they are still in Octo's possession?
That's my understanding, although I don't know, what their processing and retention obligations are there. But again, we didn't flesh that out too much because of the scope of our work. We just noted that they hadn't been ingested as part of the MOLC's investigations.
Do you know how long he had access to them after he was placed on administrative leave?
We don't. He declined to participate in the investigation. We don't know if anyone knew. We know through witness testimony and other email evidence that he was able to send email. Now, there can be various means you can do that, including through a virtual private network, through a personal computer. So just I would hesitate to say definitively to you here today how long he had access. We knew he had some access to those accounts. I don't know if they were by virtue of his access of devices, though.
Ms. Natali, do you know how long he had access to his devices after he was put on administrative leave?
Hi. No.
Okay.
But probably just a few days.
Yeah.
I'd like to correct the record if you don't mind, just kind of jumping in. I'm sorry.
Sure.
He was asked, I think there was email exchange between him and my supervisor, Director Adams. He said, turn everything in, it was approximately a week, I believe, and then he resigned. That's, usual. When someone's on administrative leave, they still have access to their work, and I guess because of his job, he still had to sign things and only stuff he could do. But I will let you know that my office, I personally received them from the general counsel of the executive office of the mayor, probably a week or two after he resigned. She had them locked in her office, and then I had them locked in my office.
Who's
So,
she?
Betsy Cavendish.
Okay. So they were surrendered to Betsy Cavendish, and then Betsy provided them to the MOLC.
Yes, council member.
But the chief technology officer responsible for collecting Falchecchio's devices.
I don't know if, I don't know, the term responsible, when someone resigns, you turn them in to, or leave them in your office or whatever. Octo, in my experience, they get things, when it's broken or they have to fix it or update it. So I'm unsure about who's responsible. Like if today was my last day, I would just leave them on my desk and whoever's at my office would turn them into HR or whoever.
Yes, but you haven't been accused of harassment and you weren't asked to provide them specifically to surrender them.
I don't believe he was asked to surrender them.
Um,
And like I said, I can go through everything. I mean,
sure, and
know-
we certainly have plenty. Well, don't worry, we'll have plenty of time.
I'm here all day. Yeah.
Great.
Yeah.
But I just, because you jumped in to assist. He had his devices during his admin leave, which was about a week.
Yes.
He was also asked at that time not to be communicating with complainants, which he did using those devices, which I believe you determined.
Well, I believe an email was sent and one of them was on the email. It's like a group email, but upon, I hate to sound lawyerly, information and belief and our investigation, all of his communications with complainants were on his personal cell phone device.
Yes, but he had been asked not to communicate with them.
Yes, and I don't think he did.
Okay, I'm gonna go back to Ms. Curtis for a minute. On page 34 of your report. Second paragraph. Towards the end, despite the anticipation that Mr. Falchecchio may need to continue to perform some essential functions, Mr. Adams also instructed Mr. Falchecchio to return any government-issued equipment, i.e. phones, laptops, desktop computers that he may have used to send communications, emails, and other messages to the complainant. Am I reading that correctly?
That's correct. We've cited to footnote 64, which is a March 9th, 2023 email from Mr. Adams to Mr. Falchecchio. And then according to our interview, the chief technology officer would have had the primary responsibility to collect his devices and equipment, although obviously it's not necessarily where it went in this case. I think that was new to us today. But Mr. Adams recalled that they were turned in at some point. We didn't have the fidelity of who exactly received them and locked them.
Now, your report also said that the chief technology officer was responsible for collecting Falchecchio's devices. What led you to conclude that?
We cite to the interview of Mr. Adams that we conducted on February 9th, 2024.
Okay. The appendix shows that you didn't request Falchecchio's electronics or records from the chief technology officer. Why was that?
At the point that we were in our investigation, we We were not reinvestigating whether he conducted sexual harassment. I think what our main critique for not having, for the MOLC not having reviewed and ingested what was on those devices was because that is a best practice always. There may be text messages, there may be things, there may be apps he's installed against government policy, and being able to touch and feel those things would be important. Again, we weren't relitigating. We had already validated that he committed these offenses, but we felt that it was an investigative shortcoming that did not happen. Now, the sexual harassment officer, to her credit, said that was one thing she wished she had done, but she also felt like she had reviewed through their centralized system the things that he would have been able to send through his official accounts on those documents. So things like emails and other things that would register within, the government records, that she did searches of those. And that was part of the 350 thousand some odd documents we had were emails that she had sought to review. So while this wasn't maybe a huge gap, it was not a best practice that those weren't, because there can be ancillary. Just having been a prosecutor for many years, people's lives are on their phones and even their work phones. We also noted that, even though, and we agree with the MOLC that, at least according to the complainants here, many of the offensive activity occurred using his personal phone. There was indication that the complainant's work phone was also, had evidence on it of his bad activity. So again, a best practice would have been, let's get all the government phones. Those are something we have control of. So that was what grounded our conclusion.
Did you have any recommendations on whether the MOLC should have attempted to acquire Falchecchio's personal devices?
We did. I think we thought they could ask for it. They didn't have law enforcement authority, so they couldn't compel it. And that sort of bleeds into our other recommendation, which is at some point they could have sought advice about whether they want to turn to law enforcement, given what we knew was on those devices, the personal devices, that is, to see if they could compel their production. That, again, hindsight is 2020. But that could, that would be a recommendation we would have in the future, to the extent that there is something we know that's beyond the reach of a sexual harassment officer investigator, that they consider consulting with law enforcement and saying, can we get a search warrant?
Mhm.
Can we go do this? Because there could be more there.
In your experience investigating these types of crimes, can this evidence be retrieved at this point from his personal devices?
It's impossible for me to say, although depending on the application he used, it's possible it could be retrieved from a service provider like Google and others that are kept, and preservation orders can be given for that. There are also invaluable things you can find on phones, photographs and the like, that can be gotten from the cloud once you know the details of the iCloud account or whatever the interface is that he has. So all is not lost, but certainly better to have the actual phone as quickly as possible. And I think, again, that underlies our recommendation that there has to be just enhanced training and sort of a quick steer, because it's very easy to look back and say, here's what you should have done. And we don't want to be hazardous in that regard. But at the same time, we want to make sure that we're, hopefully this never happens again, but if it does, that you're nimble to make those calls and say, oh my gosh, there's something terrible on his personal phone. Can we get a search warrant? Could we get a subpoena? Now, that doesn't give you the content of the phone legally, but it gets you to the point where then you have physical control over the phone and you can get a search warrant to search the contents of the phone if you have probable cause.
I can provide additional.
Go ahead.
Yeah.
Sure.
So, can you hear me?
Again,
So we also are aware, according to the complainants and witnesses we've talked to, that he did, first of all, use his personal phone for communicating with them. But he also used specific apps where once he sent the message and it was read, it would disappear. So The likelihood that there's still something on the personal phone is slim. It doesn't mean it's not worthy of looking, but he specifically used these apps, which made it very difficult to track what he was saying to these individuals. And he especially used those apps for explicit content and conversations and he set the settings so that, they would just disappear once they were read.
Would that be like WhatsApp?
WhatsApp and Snapchat.
I see.
I thank my co-counsel here for bringing me up to speed on the latest, and I really credit the complainant for identifying that and catching it. I mean, that's
Yeah, and the complainant
incredibly
was,
brave.
she actually took pictures with her government issued phone of the messages she got on her personal phone. So that's how she was able to retain them, because she knew that also when you try and take a screenshot on your phone when you receive a Snapchat message, it alerts the sender that you've taken a screenshot with the phone. So she would use her government issued a separate phone to take a picture when the images and texts were sent to her.
Wow.
So that's what she retained and as part of her evidentiary record on her own behalf.
And I will tell you, the original complaint that came in, had it not been for the demonstrative evidence of that, I mean, it's hard to understand how graphic something is. If you don't have a picture, right, it's worth 1,000 words. And I think that really made a huge difference in determining the severity of that. So again, it's not a perfect world, but I also wonder, just as the prosecutor in me, whether those disappearing messages are saved somewhere on a server that law enforcement could get, whether it's, probably not WhatsApp, but perhaps there are other mechanisms to do it. But yes.
Should there have been a criminal referral last year when the MOLC was investigating?
So again, I don't want to fall into the very easy trap of hindsight and the benefit that it provides. In my experience, where I was in charge of criminal referrals at the CIA, where we had a statutory obligation to refer any crime, not only of a CIA individual, but also of anything we observed during the course of our mission of other individuals. It was a heightened standard. When something constitutes a crime, at what point does it cross a threshold is a very difficult thing. And I know we talked during our interviews of witnesses about this, because one of the complainants, in my opinion, raised a criminal offense on its face. And that is what underlies the criminal referral we made. We talked to the MOLC about this. They're very experienced attorneys, and they were struggling with the same issue that is the perennial struggle. I know they credited the fact that these complainants had very capable counsel and who understood, going to law enforcement and could guide them through that path. And they felt like, were they to go unilaterally without their consent, could almost be construed as a greater foul. So it's a very hard calculus, and I don't want to undermine how difficult that is. I do think, though, when someone alleges that there has been a sexual assault, that you have to very quickly, whether you're informing the victim, doing it in conjunction with their counsel, or otherwise, consult with law enforcement immediately, because cases do not get better with time for the prosecution. And I think, in my opinion, I don't know whether they should have made the criminal referral. We did make the criminal referral. It's difficult for me to stand in their shoes. I know they thought about it. But, had I been in that position, I think I would have done it in consultation with their counsel. Having been a prosecutor on the other side, it doesn't and this is part of giving advice to complainants. If you many complainants say, I never want to go in court. I don't want to be out there. Prosecutors understand that very well, as do the investigators, and they know, and they will tell someone, we're not going to go any further than you want to. And so just affording them that opportunity to talk to someone in law enforcement early is critically important to gain that trust, because if there is a crime, it should be investigated as such.
So you did make a referral for a criminal investigation. This seems like a pretty significant finding. I'm curious why the decision was made to make that a footnote in the report.
So we consulted with the Inspector General's office because we said, look, we've found a crime. Now, if you read our contract, I know carefully, and it talks about making a referral if there's sort of a prospective or ongoing or a new offense. And so we were struggling. This isn't new. This is not something that, wasn't known completely. We didn't further develop the facts because we thought they were very well developed. But we wanted to raise it with them because we don't know what law enforcement was looking at. We didn't know if law enforcement was looking at this particular issue. And the Inspector General's office said, if you feel a crime report should be made, you should make it. And so we did. And so we made a separate letter and we decided we wanted to, again, in the interest of completeness, we wanted to reference it in the report. We wanted to recommend that a crimes reporting structure was put in place and guidelines. But we sent a separate letter that had much more detail because in my opinion, doing a crimes report of just saying there might be a crime, go look for it is not effective to law enforcement, but instead you have to be particular. Those particular facts are very graphic and revelatory based on the, as a prosecutor, it's the who, what, when. And we put those graphic facts in our letter to the Inspector General and said, we believe this alleges, if true, a crime. And so we didn't want to have that be a centerpiece, again, protecting the confidentiality of the victim. It's also not really within the ambit of what we were asked to do, but we wanted to make sure it was reflected that we had done that. Could we have, again, hindsight in 2020 in our report? Absolutely. Maybe that's another requirement of the contract is that you set forth with specificity whether you have made crimes reports and why, not necessarily what they are.
So in addition to the report you provided with us, you wrote a letter to the Inspector
did.
General providing information for a criminal referral.
We did.
And did that letter recommend which law enforcement
No.
body? Okay. And Mr. Lucas, has that criminal referral in fact been made?
Referrals have been made, but I'm not at liberty to discuss to whom and about what, for fear of undermining their work.
And you used the word referrals, plural. So you've made referrals to multiple law enforcement agencies?
Referrals have been made to those who have jurisdiction over the issue.
Can you specify whether those are federal entities or local entities?
For not.
Okay. Ms. Curtis, are you aware that the Attorney General is investigating Mr. Falchecchio for possible criminal conduct?
I'm not sure if I'm aware exactly of that, but I deduced that when I had a call with them about the contours of the records that we had that was arranged by the Inspector General's office. I believe that was last week.
There was also some news coverage yesterday of a letter the Attorney General sent to the Mayor's Office of Legal Counsel
I
requesting
did see that.
records. So you're probably more free to speak about that than you would have been prior. So the Attorney General is seeking the investigative file from the Mayor's Office of Legal Counsel and the Office of the Inspector General. Do you believe the Attorney General should have access to it to conduct a fair, prompt, and thorough investigation?
I guess I would not characterize it necessarily as my belief, but if a law enforcement agency has the authority to conduct an investigation, it is imperative that they are given access to the evidence that's relevant to that investigative legal mandate.
Thank you. Okay, turning to the review of the Mulk investigation. In your opinion, what were the main discrepancies between your review of the Mulk's investigation and the original Mulk reports?
I'm not sure I would characterize them necessarily as discrepancies because we weren't doing a reinvestigation, but we did find, as I laid out, that there were some what we thought pretty significant concerns with the sort of staffing and the training and the confines of the investigation of this. This was a case where clearly, as you noted, they had to operate outside of the mayor's order because there was no sexual harassment officer in the office. And I think we can debate whether having a sexual harassment officer internally who would report, for example, to the Office of City Administrator would have been a better formulation of this. But I think at base, our main concern was about the fact that once he had resigned and it was no longer sort of just a personnel matter, and a second complainant had come forward and a third complainant had come forward, and there was sort of no longer the exclusive province, I would say, of the mayor's order, that someone at some stage should have said, wait a minute, maybe this shouldn't be our Mulk show, who did an amazing job given the resources that she had. Maybe we need to stop a beat. He's no longer, the bleeding perhaps hopefully has stopped. And we now need to say, this is a larger issue. This is a bigger thing. Someone's alleged a crime. We need to regroup and see whether this should be referred out to law enforcement, whether we should get an independent investigator or some combination of such to address this high level issue. And I think the Mulk was trying so hard to get the job done as they were asked to do, and to do it within the timelines of the order, that they probably lost sight of, again, hindsight is 2020, of how serious this was. And how much, how everyone is going to be looking back at every step they took and analyzing every decision they made. So that was sort of the biggest concern we had was just there wasn't enough consideration of breaking it out of the Mulk show mold and putting it somewhere else. We also had concerns about trying to balance sort of transparency to the public, which is the mayor really wanted, right? I mean, obviously this had come out. She wanted to talk about it. There were press conferences. What does that do when you have an internal investigation going on? Like, how can that not churn and cause tremendous pressure on someone? So that was also a problem. Again, all counseling toward, it shouldn't have just been the Mulk show doing it at that point. And then finally, again, the public release of it was that was traumatizing to both complainants, actually. The second complainant, it wasn't about her, but she remarked to us very vividly how that affected her, because she thought, mine's next. And so they're going to know who I am. And so again, I don't think there was sort of ill will. People were trying to, we said not bad faith. We didn't find evidence of that. Just because we didn't find evidence doesn't mean it wasn't true, but they were trying to get information out there. But the effect that had, just this constellation of events all conspired to give the appearance that the council got, and that the public got, and that the press reported on, which was, this looked like a cover up, or this looked like someone was sweeping it under the rug or minimizing it. And that's not what we found, but you can see why that observation was made. And so we were trying to unearth all of that so that we got to the bottom of it.
Thank you. We have been joined by our Ward 5 colleague, Councilmember Zachary Parker. I've put 10 minutes on the clock for the rest of my round, and then we'll turn to him for questions and any opening statement he may have. Ms. Curtis, on page 34, footnote, we're skipping that, never mind. Sometimes we get to these topics before I reach them in the memo. Okay. On page 47, the report notes that the Mulk show believed some witnesses were not forthcoming with her during the investigation out of a sense of loyalty to the mayor and her senior staff expected at EOM, and because people generally feared Mr. Falchecchio. In what ways do you think the sense of loyalty to the mayor and senior staff impacted the overall Mulk investigations?
I'm not certain that it impacted her ability to get to the evidence that she needed to get. The findings were sound. I'm not sure that anyone would have, and when we talked to her extensively about this issue because it really concerned me. Because again, this gets to the heart of, should this have been an internal investigation? People were scared. People thought this is the witnesses we talked to said, it was more along the lines of like, I'm not lying. They weren't lying to the Mulk show, but they were scared. And they would say, and they would tell the complainants even because people were talking, it's the mayor's office. They're going to tell the mayor. And I don't want this to hurt my job. Like it's the mayor's office of legal counsel. And I think one of our critiques of the investigation, no matter what she said about being independent, no one's going to actually think that, right? Because they work for the mayor, and that's the malady of having an internal investigation. So I don't think that she was misled. I don't think that she was lied to. I think that it was like pulling teeth to get people to talk to her. And it was, we worked really hard to explain our role here. And our team was incredibly impressed by the folks who came forward and really were candid about their views about how this all went down. So I'm not sure that it manifested as skewing the investigation, but it was a real problem.
Yeah, thank you. I want to move on and discuss your separate investigation. Beginning on page 89, the report found the witnesses changed their stories. What do you think that says about the workplace culture at DemPed and EOM?
Let me just make sure I'm
Yep.
getting to the right point. On page 89, let's see, can you help me find?
On the right page. I might have the wrong page. Okay. Do you remember the part of your report where,
Okay.
where you found that witnesses had changed their stories? And what do you think that says about the workplace culture at both agencies?
And so I'm trying to isolate which witnesses, not that a lot of witnesses changed their story, and
No,
I'm trying to remember which witnesses.
Oh, was there a specific instance where the MPD officer said something in one interview and then said, no, I never said that? The John hire, I think was the quote. That's a John
We
hire.
did have, I think, I'm not sure it was the MPD officer. I think, was it a different one? But I think I'm now recalling a lot of in phase 2, we wanted to know what happened in the workplace, right? And the environment and what we had heard. And we're going with sort of like the rumor mill. We're hearing things. And one of the issues was this term, John hire. And the question was, and I think the Mulk had alluded to, but she hadn't developed this factual record because it wasn't within the scope of the sexual harassment. So we wanted to develop it. And one of the witnesses that she talked to, we called the person witness 1 in our report, had told the Mulk, oh, well, everyone knows about John hires, or I was a John hire. And so we thought, wow, that's significant. So we went and we tried to get to the bottom of what does John hire mean? Is that a widespread use of the term? When we interviewed the witness, she indicated that, oh, it's not, she retracted somewhat that statement. Now, whether the Mulk didn't drill down on it like we did, but I think
for us, that was significant if there was this belief in the workplace, true or not, that again, it was part of this favorite sexual attraction based hiring that is at the John hire. Now, we subsequently interviewed other witnesses who said the term John hire just meant part of like, a clique or a cabal. And there were, I won't identify the witness, but another female witness we talked to was like, I'm a John hire. Do you think I fit into that category? So again, we were pushing the envelope with everything we had to
Mhm.
get to the bottom of it. But we will say that one witness, and so what does it say about the workplace culture? Maybe it's just that the MOLC wasn't pursuing the workplace culture angle as much, but it definitely, when we started drilling down, the witness retreated. That her testimony that this had been a widespread, everyone knows about John hires. Like this is a chronic problem with him. And like everybody knows what that means. And when we actually pushed, the witness said, well, I mean, it doesn't really mean,
Doesn't
like,
mean.
it doesn't mean all that.
Yeah.
Like the term John hire is used, but not necessarily to deal with sexual behavior.
Understood. On page 94, you wrote that even consensual relationships between a superior and their subordinates may not have violated the mayor's 2017 order, but it did create risk for the district. Can you expand on that?
Sure. And that's something obviously that's changed with the new policy. But as our reading of the previous mayor's order was that there was supposed to be guidance issued about how to report supervisee, dating relationships or romantic relationships. And we found no evidence that happened. So there was a gulf in guidance. And so it didn't appear to violate any policy or the order at the time, but obviously not a best practice within the district. And I think the district has recognized that rightfully and has addressed it now. By creating exposure or liability, I mean, it's exactly what happened here. Not only does it, even if it's a consensual relationship, it can have a toxic effect on a workplace environment.
This is my last question for you, so I'm just going to charge ahead. What do you think is the most fruitful next step council and the executive can take?
So ideally, I think council working, hopefully, we've been helpful with our report to unearth things for you. I think coming together and saying, are there new legislative authorities needed or not? Are there just directions that need to be given? Because they have a lot of authorities. And I would hate to see, you spend a lot of time working on legislation that either isn't going to fit or that won't have the desired end state. And so to the extent there can be a partnership working together with them to achieve these goals as quickly as possible would be, I think ideal from my vantage point.
Thank you very much. And thank you to you and your associates for your hard work on the report. So Councilmember Parker, our panel, I've been questioning our independent investigators, but our panel also includes the MOLC and the Inspector General who will give their testimony next. So feel free to have at it. I don't know how long you're here, but.
Thank you, Councilmember Nadeau. And admittedly, I'm coming from another hearing, so some of my questions may have already been asked and I didn't have the privilege of listening in. I'm going to start with you, Inspector General. There's been a bit of a back and forth between the Attorney General, your office, and the MOLC about documents. And the Attorney General would say he has requested documents and has been told he can't get them. Then there's been words that, well, maybe the MOLC is saying we've sent over all the documents. So my question to you is, has your office shared any documents related to the relevant investigation with the Attorney General?
No,
And what is the reason for that?
we're in the process of determining which records we can turn over to the Attorney General. There hasn't been a back and forth between my office and the Attorney General.
There has not been a back.
There has not.
Have you received a request from the Attorney General for information?
Yes, I have.
And so that to me would be defined as a back and forth, or at least a request. Has there been a response from your office related to that request?
Yes, we're determining which documents we can turn over to the Attorney General.
Why not turn over all documents related to this incident?
I don't have all documents
Why not turn over all documents that you do have to the
because
attorney?
there may be some privilege attached to some documents that were received during the investigation. That's why we're trying to determine what we can turn over to the Attorney
Now,
General.
I'm no legal expert, but I can imagine you couldn't share that publicly for concerns of privacy. But if the Attorney General is asking for it, what privacy concerns are there that the Attorney General can't have insight to?
It isn't a privacy question. It's a privilege question. The records do not belong to the Office of the Inspector General.
Who do they belong to?
In some cases, they belong to MOLC.
Okay. So all documents that don't belong to MOLC, you can share.
To the extent I can, yes, I will.
So are you able to commit right now that all documents that are not owned by MOLC, you are willing to share?
That commitment has already been made to the Attorney General.
And what time frame can we expect these documents? Because the appearance from the council and the public is that there's some nefarious behavior going on. There's information that is being shielded from the district's attorney general. And while I'm not necessarily saying that is the case, that is certainly the appearance. And I would imagine, given the high-ranking official that is central to this investigation, we would want to make sure even the appearance of nefarious intent was avoided. So is there a time frame that we can commit to that you would get the information to the attorney?
I do not have a time frame.
What is a reasonable time frame in your judgment?
There's over 300,000 documents that we have to go through. I am in consultation with the Attorney General on what we're going to be.
But what's a
turning over to
reasonable
them.
time frame? Is this a few weeks, a few days, few
It
months?
could be a few weeks. It could be a few months.
So if I could ask for you to come back and confirm what is a reasonable time frame. So we've all heard that we take this very seriously. We've all heard that we should act urgently. We've just now, as a district, spent a lot of money on this investigation. Again, it just strikes me as odd that we wouldn't be forthcoming with all information related to this. I want to come to the MOLC.
And I understand the appearance part of this. This is what I do all day, every day. I work with law enforcement all day, every day. There are document requests. There are processes we must go through in order to protect confidentiality, privacy, and privilege. This is what we're going through right now. I am not in custody of any records. The independent counsel holds those records. We are working with the independent counsel to determine what we can turn over to the Attorney General.
And the independent counsel in this case, I'm assuming, is the contracted law firm.
Correct.
Okay, so I want to come to the MOLC and very similar questions. If the MOLC is in ownership of these documents, what precludes us from sharing them today with the Attorney General per the Attorney General's request?
Hi. Madam Chair, may I just do my intro statement this time?
I would prefer an answer to my question.
I'll answer it.
respectfully.
I'll
Yes.
answer it. I'd like to respectfully explain who I am and why I'm here.
Sure.
Thank you. It's 2 seconds. Give me
Okay.
2 seconds. Good morning, Councilmember Nadeau, Councilmember Parker. It is nice to meet both of you. I'm Vanessa Natali. I'm the Deputy Director of Mayor Bowser's Office of Legal Counsel. I've served the district government for 17 years. My first 7 years as a line attorney and a supervisor at my beloved OAG. My next 5 years as general counsel at the Office of Administrative Hearings, and now my current position at the MOLC. The MOLC is a small but mighty office comprised of 7 lawyers and 1 legal administrative specialist. It is led by Eugene Adams, who previously was Chief Judge at the Office of Administrative Hearings and was at the Office of the Attorney General for many years, 14 of which he was the Chief Deputy Attorney General. All the other lawyers in our office came from other DC agencies and have the experience and the integrity to work at this level of government. I don't bring up this breadth of experience to brag, but to show you and the public that we are public servants through and through. We are thoughtful, accountable, and most importantly, honest, brutally honest at times. I hope to answer all your questions today, but if I cannot, due to privacy considerations or legal privilege, or if I simply don't know the answer, I will tell you. Thank you. Thank you for that.
So I go back to my question. Why can't the MOLC today turn over all documents requested by the Attorney General?
So the question that you have, it's almost a false premise. Should the MOLC turn over documents, an investigative file?
No, my question is, why can't you? Or why haven't you rather? So the Attorney General has made a request to the OIG and MOLC, the OIG is saying the documents are owned by MOLC. That's why they
Okay,
can't show.
okay, I got you.
So if the documents are owned by MOLC, why haven't you? Why?
Well, that's interesting. We have offered to give them the relevant materials related to complainant number 2, and actually a few
Why
others.
not turn over every document?
Well, would you turn over every document to someone that just demands it and may not have the legal authority to see the whole investigative file?
Our Attorney General doesn't have the legal authority to review the documents is what you're suggesting.
No.
That's striking.
The legal, the
So,
file,
wait,
the
wait.
administrative
I
file,
just want to make sure I'm clear. So the MOLC's position is that the Attorney General does not have the legal authority to review the information.
the Attorney General does not have the subpoena power or a court order to look at the administrative file and the final report. The mayor's order, which has the rule of law, states we cannot disclose unless it's by a court order.
Part of the reason why the Attorney General, as I understand it, wants the information is because there may be a need to follow up for further legal action, which was what was documented in the
Correct.
report, right?
The Attorney General's
Wait,
office,
one
the
second.
Attorney General's office had this information last summer.
1 second. Respectfully. Does the Attorney General have the authority to pursue legal action
No,
against Mr. Falchecchio if there are warranted crimes committed?
it depends on what crime you're saying. They have a,
Well, now, I want to come to our legal friends. In the report, there was suggested crimes that may be warranted for follow-up. What were those crimes?
That involves sexual assault.
Sexual assault. Does the Attorney General have the legal authority to follow up on that accusation?
not adult sexual assault in my opinion. That is the purview of the U.S. Attorney's Office.
Does the Attorney General have the authority to make a referral related to sexual assault? A referral to the U.S. Attorney or someone else?
I would think so, yes.
Okay, so if that's their legal authority, in order to substantiate the claims from our legal partners that were contracted, why would we stand in the way if there is a potential crime of sexual assault?
We are not standing in the way. We offered those records to them.
So all documents related to sexual assault have been
Yes.
referred. How many
Yes.
documents have been shared with the Attorney General?
No, they did not accept them. In fact, I offered them. They were told, I was told that, we have a normal back and forth. We talk to them all the time, that office,
Respectfully,
And
how
I
many,
was-
how many documents were offered?
all of them. All of the
All
documents that are,
300,000 documents?
I think we probably even have we have an incredible amount of documents. Any
So I'm asking for a
document,
number.
I don't know.
If you can give me a ballpark, because we are being told there are 350,000 some odd documents.
There's that we looked at, we pulled emails, we have everything, anything that is related to sexual assault, indecent exposure, any other crimes, we have offered to give to the Attorney General's office.
And why didn't the Attorney General accept them in your perspective?
Well, I was in the conversation, and in the conversation, I said, okay, I think, and I can give you what's related to the criminal
So you get to
referral.
make that judgment of what's related.
Yes,
Who else gets to review the documents to determine if it's related or not?
It
Now,
was
I'm
re-
not- I'm
It was
not-
related to complainant number two's statements to us and I believe to Arnold and Porter. So anything related, and I even found a couple things that may be ancillary, like,
I'm
you know.
not a legal expert, so, but I do understand that Attorney General and Councilmember, if I could have 2 extra minutes. I do understand that the Attorney General doesn't have subpoena power based on the limited authority granted to that office in DC Code. A question I have, and maybe Councilmember Nadeau can help me, is whether or not the council has the authority to subpoena information. Because to me, it just seems outrageous that something of this magnitude and importance in relation to the mayor's team gets to determine what documents are therefore shared. Now, again, I think we should be very concerned by the appearance of malpractice here. And it just,
Well, that's quite a word to use when you're talking to me. Okay,
yeah,
because
yeah.
that is
It-
not
it
the
was-
case.
It was a word intentionally used because
Yeah,
to me, it doesn't even just strike me as odd. It strikes me as you're hiding something.
I offered it to them. How
And
can
they-
I hide something I offered?
Okay, so we don't have the Attorney General here, but from what I've understood from the Attorney General is that it hasn't been that simple, that it wasn't just offered and they declined it. It's been a back and forth between
In
both.
fact, the Attorney General's office specifically told us they did not want to go in a back and forth with us.
Okay. I do want to go in a different direction, but I do hope to follow up on that because it's in the interest of the district that these documents
I work for the district and
Yeah.
I've worked for the district for 17 years.
work for the district. That's right.
Yes.
That's right.
And I have offered the materials that are relevant that Arnold and Porter pointed out.
You
to
offered,
the offer.
you offered the documents that you determined were relevant for the Attorney General to see.
I offered the documents that are related to complainant number two, the ones that we have.
Again,
I have no others that we are hiding. This is
Let-
no cover up.
let me
This is
ask,
nothing.
thank you. Let me ask our friends and Councilmember, if I could just have 2 minutes and I'll wrap up. Do you have the documents in your custody that the Attorney General was requesting?
I believe I do, without knowing exactly what the Attorney General is requesting. We have the vast majority of the documents ingested.
So what precludes you from sharing the documents with the council and or with the Attorney General?
So our contract is the only mechanism where we can lawfully turn things over to. And I just looked at it before I came here because I figured you would have this question. As long as someone says it's pursuant to this law, either district or federal law, that's good to go. We're not blocking. We can pass any information.
Well, yeah, I would be
Pursuant to law.
interested in that. So Councilmember Nadeau, I would love to work with you to get because I think that's outrageous. Even if there isn't anything being hidden, I think it's outrageous that someone gets to tell the Attorney General and thereby the district, you don't have a right to see these documents of arguably the second highest, most important official in the government who's potentially being accused of illegal activity. That is outrageous. And it's an embarrassment of both MOC and district government as a whole.
Councilmember Parker, you are being extraordinarily inflammatory and misleading to what has been said.
I take that as,
Any-
I take that as
any-
disrespectful.
any-
And quite
correct.
frankly, this is my time to ask questions. But my perspective, in addition to what you just said being disrespectful, is that this smells of malpractice and it is an embarrassment. I want to keep going. And I didn't even come in here with all of this energy. I just had some basic questions, but I also know that there is a tendency for government officials to ask for information and be told no. And I'm of the mind that our Attorney General has the right to see any document related to a criminal activity, whether or not they have the legal authority to prosecute there. I will move on. Councilmember Nadeau asked about the recommendations you would give the council, so I won't go into that. But can you speak to how many hours went into completing your investigation?
Liz, do we have those numbers? Sorry, I'm going to turn
Yes.
to my expert here. a lot, technically. $1,617, give or take some
Yeah,
hours.
I'm gonna repeat that, 1,617 hours.
Yes,
Got it. And you commenced your work on what date?
on January 15th, 2024,
And you concluded on what date?
on May 10th, 2024,
Got it. That's helpful. Um,
with approximately 25% of our budget remaining. So we saved some money for the taxpayer, which is something we're pretty proud of. Or less than 25, sorry. We were under budget by approximately $94,000.
that's unheard of.
I know, my law firm might not like me saying that.
I mean, again, I'm no legal expert, but it's not often that a law firm says, hey, we're giving you some money back. Anyway, thank you for that. And I just want to come back to where we ended. I'm gonna end, I promise, council member. Thank you for being so gracious with time. So pursuant to what code in particular would the district have access to the documents in question?
Sure, there's no code provision specified in the contract, and I'll pull it out right now. Do you have the contract, the definitive? Here we go. Sorry about that. Of course, I'm not finding it right this second. I'm sorry. We have that in
And
here.
while you look for that, I
Sorry
just want to
about
make
that.
sure I'm
I'm
clear.
sorry. I
You-
don't want to take up your time.
No, no,
doing
you're
mine.
good. You
Okay.
mentioned, or let me just ask it simply, how can we get the documents from you all? You were saying pursuant to blank,
Right.
the
So,
district would have access to the documents.
so we have a contract with the
Yes,
Inspector General's office. We have, as the Inspector General noted, we have custody of the majority of the documents at our offices. If pursuant to the contract, we are instructed to produce under this provision that mentions both district and federal law, and I'm going to find it shortly.
Okay.
We will do it as quickly as we possibly can. I think our estimate, Liz, was within 24 to 48 hours.
thank you. That is helpful. I want to thank you all for your work. Also, thank you for coming under budget. And I just will reiterate that this is of great importance. I'm not sure what the outcome of any investigation might be. But again, I think it sends the wrong message for us to appear that we are withholding information. So anything I can do to ensure that the Attorney General or anybody else that wants these documents, that has the authority to review them, I'm happy to do that. Thank you, Councilmember Nadeau.
Thanks for joining us. Are you going back?
I was gonna go back.
All right.
but I can stay.
Totally up to you. Just give them my regards. You go back. Thank you for joining us. Okay. I was planning already to next turn to our witness from the MOLC, so we're right on track, and thank you for providing your opening statement, Ms. Vitale. I'm going to reorganize a little bit here and ask questions in the same vein that Councilmember Parker was. So my understanding from your statement is that you agreed to provide certain documents to the Attorney General.
Yes, Madam Chair.
Is that offer still available?
Yes.
And how long does it take, and in what manner do you convey those records?
I could send it to them, probably email or bring it over, or if somebody, they're in the same hallway as me, I can give it to someone. They have been available.
Great. Then this committee is officially asking that you do convey those records. Could that be done today?
Yes.
Great. All right. I think that'll allow us to move forward from that topic.
I agree.
Okay, very good. I know that they are listening to today's roundtable and they will be following up shortly.
Councilmember Nadeau, Councilmember Parker, I found the offending paragraph in the contract. It's paragraph I.3, confidentiality of information, instructing us that we shall keep all information relating to the district in strict absolute confidence and shall not disclose, and I'm paraphrasing now, in accordance with district and federal laws governing the confidentiality of records. So that means pursuant to a district or federal law. It's very general that I can make those disclosures.
Thank you for that. Ms. Satelli also, so you spoke earlier about guidance from the mayor's order that specified what you could and could not share with the Attorney General. Is that correct?
Yes, that's the general premise. A mayor's order, it's like an executive order. This is kind of stuff I was kind of new to me until I got to the mall, or maybe recently. It has a rule of law. So in the original and the updated, it states, I don't have this, I may have actually the specific, that the investigative report, and I don't think they call it a file or any documentation, is confidential and cannot be either disclosed or something like that without a court order. And that happens a lot in lawsuits and whatnot. And because these are personnel matters, it's not because it's like there's other more important things. These are all personnel matters, and usually, and all the time, you can't disclose them. And usually if they sue you and go to court, blah, 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 we can get it. Court will say, give it and turn it over. But personnel matters, confidential personnel matters are not usually available, not just sexual harassment. As a matter of fact, last year, we were looking at another sexual harassment matter, and the Attorney General's office had kind of a concurrent investigation going on involving all the same people. And I asked if I could see their sexual harassment investigation. And I was told by them, it's a personnel matter. It's confidential. We can't share it. And I said, okay. So this is not just me or, this is how we protect, first of all, anyone who's talked to us or the complainants or anything maybe the accused said. In this case, that's not the point. So not just us, that's how all personnel matters are handled in the district. So did I answer
You
that?
did.
Okay.
And I
all
have
right,
more
sorry.
questions. So
Sure.
which mayor's order are you referring to?
The mayor's order on sexual harassment.
From
So
2017.
2017, I think it's 171. And then it's the most recent one. I think it's 2023. Yes, it's in there.
The thing that I do know about mayor's orders
Oh, here, I have 2017.
is that the mayor has the power to change them at any time,
Yes.
unlike statute,
Yes.
which only the council can change. So the mayor could, if she wanted, say, update that order and say, upon findings from an independent investigation, for example, those records could be released without a court order. Isn't that true?
I think so. I can't say to the actual, but there are district personnel regulations that state you can't do that either. So there'd be a lot of things that have to be changed. I agree. These materials should be available and able to be reviewed by the appropriate authority or court. By saying there's a court order or through law, legal means, is not obstructive. It's protective of all the district employees and their personnel matters and whatnot. So yes, they can change it. I understand the political intrigue and drama and all this, and And I am naive when it comes to this, I must say, because we've never had this kind of friction with materials like this. It's usually, okay, how about I give you this? And then if you need this, whatever, we're going to need a subpoena. I need to protect these materials. If you come to the mall, you come to me. If you come to our sexual harassment officer, who's also a lawyer, with a complaint, we're going to handle it no matter who it is. So I just don't, I understand it's misleading and everyone's got the view of it all. The attorney general, a policeman, no one gets to say, Vanessa, I'm going to come see everything you have in this office because I say so. I tell my nieces and nephews, when anybody else, you ask them what their authority is and why they're looking for it. And if it's legal, they can do it. But no one's going to come into my office and loot through my drawers just because their title or where they're from. They're just going to find a 4-year-old lipstick that I lost. But there's nothing to hide here. I'm doing my job as a district resident and like the greatest honor of my life to be a lawyer here. So I understand all the intrigue and the drama. There's nothing to hide here. There's no cover up. I could care less about that guy that's not here anymore. I met him once. No one told me there's no hiding. There's no nothing. But you don't get to come in and do whatever you want and loot through everything just because of the title. If you don't have the authority or the subpoena authority, then we have to figure out a way where I can give you what is relevant or relevant to what Arnold and Porter said without it violating the privacy considerations of the other people involved. There were people scared. Everybody's nervous. We had to assure them we will do our best. And unless there's a legal reason for us to hand over what you said about how it is to work at DEMPED, we're not going to do it. And I think you would appreciate that. You got the IG report. You gave it to your lawyers. What's the point of having lawyers if we can't protect people's privacy and rights? And I think the Attorney General would agree on that. And so, sorry for the rambling. It's just, this is much bigger than it needs to be. Sorry.
I understand
Thank you.
your deep commitment to public service, and I thank you for that. Let's do our best not to paint this process as dramatic and political intrigue, because for me, this is very serious. And what we're talking about is criminal behavior by the mayor's top advisor that negatively impacted our colleagues in government. I know you feel that way too. I just want to bring us back to that.
Yes.
Okay.
Thank you. I'm sorry. I'm dramatic. I'm Italian. The guy, it's just how I am.
Okay. So we've agreed that you will be providing the information that you had said prior you would give to the Attorney General, and they will accept it. I've confirmed they will accept it, and that will happen today. So I think we can move on from that particular thing.
Yes.
Okay. Okay. One of the things that I have been concerned about is things being leaked to the press. For example, the stories that were written yesterday about the letter from the Attorney General to the Mulk's office. Do you share that concern that that was leaked to the press?
Concern? Yeah, no, it shouldn't have gotten to this, that whoever had the letter from the Attorney General to our office, that it had to be leaked for this to come to a head. And for you to just have a conversation with me and I say, here, you can, yes, I will give you what you need.
Do you
Yeah.
have concern that the leaks may be coming from the executive office of the mayor?
I have concerns that they're coming from whoever has that information. And I'll tell you, that letter, it did not, well, I think we're in the executive office of the mayor technically, okay? But that letter only was in my office and at the Attorney General's office. We didn't pass it on. Hey, look and see what we got. This was normal. This is what lawyers do. We send letters back and forth to each other.
The report that was produced by Arnold and Porter was also leaked in its entirety before a redaction.
Yes.
What are your thoughts on that?
Those reports or anything else that's improper, and it shows a lack of trust with whoever had those reports and whoever they were given to.
Did your office have an unredacted copy?
Yes.
I'm gonna back up a little bit. Does the MOLC serve as general counsel to the mayor?
No.
Do attorneys at the MOLC serve as personal lawyers to the mayor or any other city official?
Well, we cannot represent anyone personally, but we can advise if we're asked to advise any of the mayor, any of the directors, general counsels, whatnot.
And that's on personal and public business or just on public business?
It's always on public. We're not allowed to be personal lawyers.
As the deputy director, the report identified you as one of the key decision makers along with Director Eugene Adams in making choices on how to handle the complaint process. Do you concur?
Yes.
And do you agree or do you stand by your decision to assign only one person to conduct a full-scale workplace investigation of sexual harassment allegations?
Yes, but in hindsight, as with Arnold Porter, we can talk about what we could have done differently.
Do you want to elaborate on what you think you could have done differently?
I could say that about everything today I could have done differently, but, well, we followed the mayor's order. That's what, was required of us. I don't know if I have to explain again, or maybe if you don't know, like how it eventually came back to our office, having the show to do it.
Yeah.
That was kind of awkward and not expected. The reason we were initially involved was the letter from complainants counsel went to my boss, Eugene Adams, and the mayor. So that's how we got started involved in it. So that letter alone stated, your policy alone. So when there's an allegation of sexual harassment, we follow the sexual harassment mayor's order and the process. So we didn't want to treat him differently than anybody else who whatever. And we didn't want to make it like, oh, he's special. We're going to have all special lawyers or special people take care of him. That's the naive part. Because we all knew, no one's going to influence us to do one thing one way or the other. We're just going to do our job. And we have the support and the trust of each other to know we can do that. So that's the naive part, right? So we said, okay, he needs to be treated just like everybody else. By the time it eventually came back to us and we were like, oh, who's going to do this? The remaining sexual harassment officer, I believe in the executive office of the mayor and the agencies around that we have was ours, who happened to be one of our attorneys. So yes, we could have done a lot of things different. I mean, I could talk for days about it. But we still came down to I think the proper conclusion. It was a very cathartic, but important, probably the most important thing that I never thought I'd have to handle in my career.
Now, I don't say this to rehash, but you said we followed the mayor's order. I think we know that ultimately the mayor's order wasn't followed because the right personnel were not available, right?
Oh, that's correct.
Yeah.
That's correct.
Yeah.
Yes.
Okay.
Well, we followed it and then it ended. I mean, what
Yeah.
we're gonna do,
You,
right?
you attempted to follow it, but the correct personnel were not available to follow
And
it.
you know,
Yeah.
we didn't, when this happened, you know, this was, I didn't call up when I called to say, hey, who's your son? I didn't say, we got a complaint about the former deputy mayor. You know, it was our normal process. I didn't want it, like, I didn't want it to be treated differently, even coming from me. So as you know how it came back. So
Yes.
no, we didn't.
Okay.
But at least we had a show who was a DC government employee. And also she had experience in these kind of investigations, albeit not this kind of investigation.
Yes. Now, the Mulks investigation was guided by Mayor's Order 2017-313. Can you describe the purpose of the order in this circumstance?
Okay, so I don't write the mayor's orders and
I
I spent
understand.
a lot of time with these, but here's the purpose of an investigation done pursuant to that mayor's order. It's not a criminal investigation. It is an almost emergent, like pull the plug on what could be going on at the time, you know, after hearing the allegations. It's to prevent it from immediately, like, stop it right now. Tell everybody, you know, put someone on leave, start talking, whatever. It is an administrative remedy. It is not the sole remedy. The complainants also availed themselves of other administrative remedies at the same time. But that purpose is to look at it, stop it, address it, and kind of, and then it can go on to its other things, possible criminal referrals, other lawsuits, Office of Human Rights, the other things that go through it. So that's what it is. And that's why it's like 60 days,
Mhm.
which that's still hard
Mhm.
for any regular investigation. Regular meaning one complainant, one block, not 23 witnesses and 33 interview. I mean, that's different. So that's even hard for just a regular thing. So, but the purpose is to address it right away. And it's not to be like, oh, we got to get a contract, we got to wait, everybody's on leave forever. No, it's to address it right there. And I think we did that. That was done properly. I'm explaining that right.
No, you got it.
Councilmember. Okay.
Thank you. So my understanding is that in a hypothetical case involving serious allegations of sexual harassment, the process could make a factual determination about whether the harassment occurred. And if so, the determination would inform disciplinary action up to and including termination. Is that understanding correct?
Yes, and when you say factual, it's, you know, you get the facts, but the standard for this kind of investigation is more likely than not. You more likely than not came to the office today, that kind of thing. You know, you get to different standards when you're going into civil lawsuit. And of course, the greatest standard, you know, is, you know, a criminal beyond a reasonable doubt. But this is a more likely than not. Yes.
And are there, in addition to disciplinary action or termination, are there other additional consequences possible from this process?
Yes, sometimes it's counseling. And the reason I know this is I previously was involved in, you know, supervisor and in these kind of things. Additionally, our office kind of maintains like a log of all the complaints and how they were resolved. So sometimes it's counseling like hey, supervisor, or hey, so-and-so, or just colleague, can't comment on how people look. And, you know, it makes them uncomfortable, makes someone uncomfortable. You know, it could be just everyday workplace, living and working in a workplace. It could be counseling of what's considered sexual harassment. And it's, you know, it's not what everybody would think is sexual harassment. It's what the person who is the unfortunate recipient of. So we've had some you know, when I was at an agency, counseling, like, oh, you can't do that. That's not okay. You know, talk to the complainant. Are you okay with that? Like that kind of stuff. So it can be very minor, but that's actually very important because that directs everyday safety and comfort in the workplace. So that's important to me as well.
And the mayor's order is not intended as a substitute for a legal process like a lawsuit or EEOC complaint.
Absolutely not. Yeah.
And the show's job is essentially to make a factual determination as to whether sexual harassment occurred to inform a decision about disciplinary action or others as you described?
I would say yes.
Under the 2017 mayor's order, when an allegation of sexual harassment is made against a deputy mayor, who's responsible for investigating the allegation?
I do know this just because we kind of played that dance. I believe it was, if it's a deputy mayor, it's the sexual harassment officer in the city administrator's office, because the city administrator, I believe, is kind of oversees the deputy mayors.
That's correct.
Yeah, okay.
And
thank
at the
you.
time of the allegation involving Mr. Falchecchio, did the office of the city administrator have a designated sexual harassment officer?
No,
Did DemPet have a designated sexual harassment officer at that time?
no,
Did MOLC have confidence that the sexual harassment officers in every agency were adequately trained and capable of investigating allegations fully and fairly?
that's not part of our job or mandate. I don't know.
MOLC had confidence in its own show, in part because the
yes.
officer had legal training, is that correct?
Yes, but we also all worked together for the previous 6 or 7 years.
But just to be clear, having MOLC's show investigate allegations against a deputy mayor is a deviation from the mayor's order. We talked about that earlier.
Yes,
Yep. The MOLC show reviewed more than 15,000 documents of evidence related to complainant's number 1 allegations, including text messages and photographs that were provided by the complainants. Is that correct?
yes, and would you mind, may I elaborate on that?
Absolutely.
So part of what was hard for the Mulk show, okay, he's a colleague and a dear friend, but we're gonna call her the Mulk show, right? Let's do it. We initially, okay, you're gonna do this. In any investigation, usually they say, here are my exhibits, or here's the text messages or whatever. We were not given any of those. She had to go over to complainant's counsel's office, look at them and write them down. We were not given, custody or whatever you want to call of the documents. So that was a lot of time as well. And I don't know, 15,000, it was a lot, and we also did our own pulling of emails of the complainants and other things.
Do you know how much, on the whole thing? How much time was spent on the investigation? Or specifically counsel's office? Do you know how much time she spent specifically at the counsel's office looking at?
I think we actually have that. I mean, I don't know, maybe 17 or 20 hours. But I think the last 2 times, one of our colleagues went with her to assist
Okay,
because it was a lot.
it's a lot of documents.
I could get you the exact numbers because
That'd be great.
Okay.
So despite reviewing these extensive amounts of evidence in complainant's possession, did MOLC acquire or attempt to acquire the government issued electronic devices of Falchecchio?
Yeah, I had them. Yes, they were in our office.
Okay, and so you had access to his devices for
Yes.
review, and were they reviewed as part of the investigation?
No.
Why not?
Simply, the complainants has told us that most of, everything they did was, with back and forth with him was on his personal phone. Also at the time, frankly, I didn't want to open them or touch them for fear of altering the materials. As a former prosecutor, I was very concerned about opening things and whatever. We pulled all of his emails, government emails, through an Octo search rather than going into his thing. I believe we also we may have requested the phone records, but text messages are not in the custody of Octo. You have to go to a provider. But we were given the text messages. Text message issues were really complainant 1, and they had them already. So as part of this, yes, we could have done more and whatever, but to address this and was that person sexually harassed, we had everything we needed.
Were you concerned or curious there might be information on those devices that would help you identify other complainants or victims that we needed to know about?
Now that you mention that, yeah, probably maybe our sexual harassment officer was, but we already this is not, the sexual harassment investigation purpose is for that complainant's complaint.
Yeah,
It wasn't this kind of broad scale. Look, if you gave that to us, that kind of ability, like you don't have to do all the rest of your work and you have authority and you have subpoena power and you can compel witnesses, we could have done that. We didn't have it. We do not go beyond the bounds of what our authority was. We're
should,
not going to pretend to do that either.
should somebody in government go through John Falchecchio's government phone and see what else might be in there that could be a liability for the government or a concern about another victim?
Yeah, I don't think anyone in our government should. I think it should be a police entity.
Have
Yeah.
any law enforcement authorities requested access to his devices?
As I said, unfortunately, I cannot answer that question.
The devices are still in your possession?
Yes.
Under the mayor's order, where, is that where the devices should be?
There's nothing in the mayor's order about that. This is, this is,
Gray area.
yeah, and it's kind of like it's a former employee, this is not covered. I mean, they haven't been altered, they haven't been turned on. They're secure.
Does a law enforcement entity need a court order to obtain those devices from you?
Law enforcement entities have subpoena power and also their, I guess, investigative authority that they would say, we're blah, 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 and we need this. Here's a subpoena.
And
Now,
it-
do I need a subpoena to give it to them? No.
Unlike the information requested by the Attorney General under the mayor's order.
Right, the information requested, I said, I'll just give it to you. I didn't need a subpoena.
Mhm.
They wanted unfettered access to everything we have. And, no, I'm not gonna give that to
If
some-
they had requested the devices, would they have been surrendered?
They didn't have the authority to request it. And you know what, maybe I would have, if it was related to, we had a lot of the materials that would have be on his devices.
Right.
We got
But
them
you
through
don't
other-
know if they have the authority because you haven't turned them on. Right? You don't
No.
know what's on there.
Oh, no, yeah, I mean, but we all, right, we.
Like if it's
don't.
indecent exposure, they have the authority, but you don't know if you haven't turned the devices on.
Well, that
So-
was possibly, but we have the pictures and
For that
we have
complainant,
it from the
for sure.
client. Yeah, for that complainant. And that's all we were looking at. Look, if there wants to be a full-scale inspector general or like MPD or whatever investigation, they can look at it. But I can't, I have to be a safeguard for evidence, possible evidence or anything to make sure it goes to the proper authorities so it doesn't get kind of lost in the mess of custody, or it doesn't get manufactured, or it doesn't get altered by turning it on, which you can alter things just from turning it on. They can see that. So yes, Councilmember, we should put something in the order, but it was nothing intentional or not. We had the materials we needed for the sexual harassment investigation.
Ms. Curtis, while you're here, do you have any recommendations regarding that policy for an update to the mayor's order?
Absolutely. I think you should clarify exactly what the protocols for obtaining all, both witnesses, complainants, and respondents, government devices, and also a protocol for if you believe, as we all did here, that there was evidence on a personal device, a protocol for deciding whether to seek that through compulsory process or even just a voluntary request to turn it over, which isn't unheard of, to consent. I'm assuming that the district has all the proper waivers and of privacy and everything else for the use of government devices too, and I'm sure they do.
Thank you very much for that. Yeah. Okay. We've exhausted a few questions about Mr. Falchecchio's devices that I will scroll through at this time. Okay. The Molks show arranged to interview Mr. Falchecchio, but he resigned before the interview could take place. Is that correct?
No, council member. After he resigned, it took a while for us to have the time set up to meet with the complainant, to interview them. I believe that wasn't until I hate that I know, the 17th of March. So I think that was it. So there was emails. We spoke to someone who was initially, either a friend who's a lawyer or whatever representing until, he received someone who's actually going to represent him. There was a lot of back and forth. This was after he resigned. So he didn't have to. Government employees must participate in government investigations. By not being a government employee, he's not. And I believe he agreed to, and then later said he was not going to. And we have this all through, I believe, email traffic with his attorney.
Thank you. So one of the things that I was just trying to get my head around was once he had resigned, I'm not really understanding the point of having Mulk proceed with its investigation to decide whether disciplinary action is appropriate, because you can't discipline a former employee. The show's focus is on the factual allegations, not assessing the root causes or making recommendations to improve workplace culture. And again, Mulk wasn't even the appropriate agency under the mayor's order. So why did the administration think that Mulk still had a role?
Well, it wasn't really the administration. I mean, we were flying a plane and building it at the same time. We were following the mayor's order, and the complainant still had the right to know if they were sexually harassed under the mayor's order. So that's what we did. And reading Arnold and Porter's recommendations, and yes, there could have been anything. But then what does that mean? Because of what his job was, he still gets better attention, better lawyers, fancy lawyers. We still had a duty under the mayor's order, and our sexual harassment officer, had the responsibility to finish the investigation. Yes, it was much longer and more attenuated than any other kind of investigation. But I do applaud my colleague for pointing out the factors, the issues that were not within our scope, and saying they should be looked at. That was what we, recommended, to the mayor, who then I believe sent a letter to the IG. So no, you're right. Maybe something else, but it wasn't just about the person who left. It's about the courageous, and I call them complainants. I don't use victim. I just don't. And I met the first complainant. I'm impressed. So I'm not calling her that, but they have a right to hear it from us. And it's almost better to hear from the mayor's lawyer that, we saw it, we heard you, and this is what we found. Some of the things that we didn't find or substantiate does not mean they did not occur. We did not have the evidence to say it. And they were welcome, and they could go to any other kind of EEO, there's OHR, there's a regular lawsuit. They had all those other avenues. And that's what we mean when we keep referring to their very capable counsel, who I'm sure, as you know, they know how to call the police. They know how to put a press release out. They called us every day. So it was important to us that the complainants feel heard. Yes, it ended on our desk in a very odd, after 10 other people couldn't do it. But once it comes to us, we did it, and we did it with, thank you for Arnold Porter saying, with integrity. And I'm very happy that we had that responsibility, even though this is never ending. And I also feel bad that this is never ending for the complainants, because this is re-traumatizing. So I hope you understand, despite kind of the friction I had with Councilmember Parker, they don't want to do this either. They want this to stop. And no one gets to go through and look at everything and say, oh, this might be, we're not hiding anything. Like I said, I'm disgusted about what happened to those complainants, and I'm further annoyed and angry that people are afraid in the workplace of their boss or who their boss is and blah, blah. That should never be the case. So keep in mind, that's who we are. And it is a problem, because maybe I was naive to think people should just know that about us, but that's not the case. So I'm here to tell you, you can ask me anything. You can come by my office. I'll talk to you about whatever I can. This is huge. It is big. It is, I agree. Everyone, this is political. You're a politician, I guess. And, I'm appointed by one now, but this is about real people and our offices and people, what they have to do in the office every day. And I'm happy that our investigation substantiated that this happened to these people. And I will not ever let that happen again, if anything I can control, which is not much, but what I can. So yes, we could have done it differently. It could have gone to probably Arnold and Porter, but I think they would have came down to the same thing. But we're proud that we're able to do it. And I'm sorry to ramble on, but this has been a lot.
I understand. And I think, and I agree with you. I think on all of that. What continues to trouble me is that somebody who has been so powerful in the district government for decades, and who is now, we hear in media reports, trying to worm his way back into power in the District of Columbia, is still walking the streets without any legal penalty. And so for me, that when that happens, that will be closure for everyone involved. Because
I totally understand.
as was revealed by the independent investigations, is absolutely a pattern of behavior. And men like this do not stop just because they lose a job. Men like this think they're invincible. Men like this think rules don't apply to them, and that women are just property and don't care at all about the careers they have ruined. And if I have any opportunity to use the power I have in government to ensure that he never gets to do this again, I will use that as well. So I think we're aligned.
That's all good.
Now,
I will say, that's not happening under our watch to anybody in this government. That's not happening. I will say that I had, personally, met him once when I was hired. There was no, I never had any bad or good, but we had to look at this from an independent, kind of neutral view of what the complainant said, which I understand is what people think we would never have, because we are the mayor's lawyers. Of course I am. I am proud to represent Mayor Bowser, but that also means I represent you, and I represent all our colleagues and all the residents that I'm one of. So like I said, that's our naivete, that we thought, oh, why are people going to think that we're blah, blah. Yeah, well, they are, because we're the mayor's lawyers, but that's not actually who we are. We're public servants, and we're not here for the, for the glory, the glory of coming here and having to explain this. We want to work here, and we want to represent, and we want to protect our colleagues and our friends. And that's always going to happen. And I will never allow anybody to bully anyone, sexually harass, as long as like we know it. And I can personally say that, like I got it.
Now, did the show determine why the harassment occurred and what factors allowed it to occur?
No,
And did the show actually make any recommendations to prevent recurrence? Do you know?
well, of that person, no, because that person wasn't employed anymore. But I do believe the show, just so you know, the show and another attorney in my office are a member of the sexual harassment. It's like a task force that put together like the new mayor's order. And I believe that, that kind of chain of command and relationships and whatnot, that is part of the new mayor's order. That's something I don't really do. I don't do the policy stuff, but that did come into it. So yes.
Okay. And when the administration makes ad hoc changes to the procedures described in the mayor's order, how does that impact confidence among the district employees?
Yeah, you're right. It was ad hoc because we were the last one. What were we supposed to do then? Just not have it? And I guess at the time, I can't remember. I know they had all these press conferences, but we didn't really explain at the time during the investigation why we had it.
Mm-hmm.
You know, we did not seek it out, trust
Mhm,
me.
mhm.
You know, so maybe that's kind of part of the explanation. Let me tell you why we're here, why we have it. You know, that didn't come to it. Maybe that's part of, we have to do that better next time. Transparency like that is important, but that is ad hoc how we ended up with it.
Yeah,
But we did have a show, okay, in the executive office of the mayor, which is part of EOM. I mean, you know, it wasn't the one that it was in the mayor's order, but it was a show, government employee. I don't know what else I can say, but we were
right. And I think admitting that there were no shows in all the places there could have been is something that the Bowser administration is not, they don't typically do that. Right. So you said just now, well, if we had explained yada, yada, I can't imagine. I mean, the fact that you're here today testifying and actually admitting that things could have been done differently is very uncharacteristic of what we see in the Bowser administration and from Bowser appointees. So I can't even imagine a world in which you would have been allowed to say, the reason we're doing this administration is because the city administrator didn't have a show.
yeah, I hear you. But I know this sounds corny and I'm not a sycophant, but like, I have never been told, not to say something or not to do anything. I have, my interactions with the mayor, which were nothing until this all happened. You know, I just was in a chain of command. I never got that from her. She was, we were mostly like advising, this is what happens next. This is what we do. Do people have to listen to my advice? No, but I found her very, open and actually confident in our ability and trusting us to do the right thing. And so the Bowser administration, all the other people, I can only be responsible for me and my people and everything that we do. But my boss, the finest man I've ever met, has never, ever said, don't do this. It'll look bad. You're not allowed to say that. Never occurred. So I'm very lucky, I guess.
In October 23, a new mayor's order updated the sexual harassment policy guidance and procedures. I have some questions about this order as well. Under the new mayor's order, every agency is required to designate a primary show and an alternate show, correct?
That's what you say. I haven't read it recently and I know that's what it is, but I haven't, yes.
On the current
That was in the
listing,
previous mayor's order too.
okay,
I know that just because that was when I was at general
Right.
counsel in an agency. So I knew it.
well, it's a primary and an alternate?
Yeah, we had an alternate at the
Okay.
agency I was at too, because sometimes they don't have, they're busy or they're swamped at work with their regular work. A show investigation or responsibility is extra.
Yeah.
So that's maybe something we can change.
It's a good idea.
Yeah.
On the current listing of shows, 3 agencies don't have a primary show and an additional 14 agencies don't have an alternate. Were you aware of that?
I know my agency has one.
Yeah,
I'm not the police for this.
understood. TCHR is not here, so unfortunately, you're gonna get some questions. We might have,
I'll answer those to the
Yeah.
best of my ability. They're my colleagues as well.
for sure. So why haven't those 17 agencies not designated a primary and alternate show? Do you have any idea?
I have a feeling most of them probably have them and the list has not been updated. That's one thing that I'll know drives me crazy about DC government. It takes us forever to get things changed on a website. I don't know the rules, but maybe it's not been updated. However, the new mayor's order, I'm 99% sure it says you can go to any show.
Yeah,
So if the agency doesn't have it, someone can go to someone else. But that's not okay. I mean, it's fine. Maybe they're not comfortable, right? It's someone in your office, whatever, they can go to someone else. You can do that with EEO complaints,
Yeah.
right? That's still, yeah, no. And then people leave and then they have to take the training. I mean, there's all kinds of bureaucratic like stuff that people have to do. But there are shows.
yeah, and I just keep thinking about if, if someone were in that position and they realize there's no show in their agency, they have to go figure out who the alternate show is. I mean, the list isn't updated online. It's not just an IT issue. I mean, this is like a fundamental rights issue and that can't be. And so that we will follow up immediately with DCHR about why that list is either not current or why there are so many vacancies.
No, I agree.
So Arnold and Porter's report also disclosed that the shows did not receive training for performing their duties, and it was perceived that their quality varied widely. Do you today have a high degree of confidence that adequate training has been provided to each of the employees who've been designated as primary or ultimate shows?
I'm really sorry, but I can't answer that. I don't do the training.
That's okay. Well, do you know what training your show received? And you don't have, and your
I know
alternate?
there was a training in for if you're going to be a show, and I think that was a substantial training.
What
they
was
took.
that after the new mayor's order?
I know my show, she took the initial one. She was one of the first ones from the 2016 order.
Okay.
When I was at an agency, she came to the MOLC with us as well.
Okay.
I don't know what the training for the shows are now. I know they've had them. I've just had the DC government employee regular sexual harassment for the regular
Right.
people.
And who's your alternate show? What agency?
We don't have one.
Oh, you don't have an alternate right now.
No,
How do you choose?
no, it's volunteer. Or voluntold. Well, that's a joke. No, it's volunteer. Like some say, oh, I'm interested, and they
Oh,
do.
so your alternate show is supposed to be someone within your agency. It's not,
It can be, or it can, now that they can go to other ones. I mean,
Okay.
we have 7 lawyers and really, I think the guidance is that the show shouldn't be a lawyer. I think it should, I don't know. I think lawyers, I think we're very capable to handle this kind of stuff, but maybe not because we would defend the agency as well. That's a conflict of interest appearance of it that is inescapable.
is there anyone at the MOLC who's not a lawyer?
Yeah, we got one guy. I mean, I don't want to we're very happy with him. I don't want to,
Yeah.
and if he wanted to do that and be interested, he could do it. But we're fine. We haven't had any sexual harassment
Yeah,
complaints.
so I think
As of now,
I think there is a question that remains unresolved today then, which is what training have the shows gotten? And how are alternates assigned? And also, which I didn't get to ask yet because you probably don't have the answer, is like, how can you at the MOLC be confident that someone else is trained adequately for your employees if they don't feel comfortable going to your show? That if they go to DHCD's show, they're going to get the same treatment that your show
they're
would
not
give
going
them.
to get the same treatment. Every show is different, just like people. And how they look at things are different. That's probably part of their training. I mean, I think most of training has to be, you have to remove bias. You have to, you have to pretend you're like this blank slate. That's very hard, and so it's difficult and that's how we are with people, like how we meet people, so you're not going to get the same experience.
No, but training helps with that.
Oh, yes. Yeah, yeah, agreed.
Okay, and it's worth noting, all the things we've been talking about today are about what happens after the fact. You referenced the staff training you received, which is actually the most important thing because that prevents the harassment from happening in the first place. And the mayor's order now requires that every other year. Is that right?
I don't. know.
Okay, that's what I believe. But in any case, that to me is one of the more critically important pieces here,
Agreed.
which is ensuring all employees are trained. And that is something that we will continue to follow up on as well. So the new order established a sexual harassment task force and required the task force to make recommendations on various topics, including communications to employees about the sexual harassment policy, trainings for shows and general counsel, and promotion of harassment-free workplaces. Have those recommendations been presented by the task force? Do you know?
I don't know. I know they've had meetings and talk.
We'll follow up.
I will do my best to get those answers for you.
No, thank you. I appreciate that. We'll work with you on that.
Okay.
And if we have some questions to DCHR as well. So that is all that I have for you today. And I thank you. I do want to move to Mr. Lucas. Does anybody need a break? Yes. Can we do 5 minutes? Okay, great. So we will put 5 minutes on the clock. Okay, thank you. We are going to resume. Thank you so much, everybody. Okay, appreciate patience. Okay, Mr. Inspector General, thank you for your patience. And for being here this long. Has been helpful, I think, to be able to go back and forth between folks, and have you there together. However, that does mean that we've answered a lot of questions already that I will not repeat just because I need you to answer them. There's a few things I still want to get into with you.
Well,
And
would you like me to
we're-
read my statement first?
Yes, please feel free. Thank you.
Good afternoon, Chairperson Nadeau and members of the committee. I'm Daniel W. Lucas, Inspector General for the District of Columbia. Joining me today are members of my staff to help me with the presentation. My testimony for today's roundtable will discuss the Office of Inspector General's requirements and resulting activities pursuant to Bill 25-0381, the Sexual Harassment Investigation Review Emergency Act of 2023, hereafter referred to as legislation. Legislative requirements. The legislation required the OIG to hire and direct independent counsel to review investigations of complaints of sexual harassment and violations of Mayor's Order 2017-313 against the Deputy Mayor for Planning and Economic Development and Chief of Staff to the Mayor as of January 1, 2023. 2, investigate other findings and items outside of the scope of prior investigations, including hiring, promotion practices, workplace culture, and allegations of retaliation against complainants, and review and make recommendations on sexual harassment complaint and investigation procedures of the district government. As amended, the legislation directed the OIG to provide the independent counsel's findings and recommendations to the mayor and council no later than 120 days after a contract was awarded. Procurement for the independent counsel. In discussing the procurement for independent counsel, it is important to note that the OIG is not exempt from the district's Procurement Practices Reform Act, or PPRA. As such, the OIG's procurement for independent counsel adhere to the PPRA's competitive sealed proposal requirements. The OIG issued the first request for proposal on August 2nd, 2023. Proposals received were deemed non-responsive due to non-compliance with district subcontracting requirements. As a result, the OIG issued a second RFP on August 22nd, 2023. Proposals received from the second solicitation were also non-responsive due to non-compliance with district subcontracting requirements or determined it was not in the district's best interest to proceed with an award. In advance of a third solicitation, the OIG sought a subcontracting waiver from the district's Department of Small and Local Business Development to avoid future proposals being deemed non-responsive to subcontracting requirements. DSLBD ultimately granted the OIG subcontracting waiver request on October 19th, 2023. The OIG issued its third solicitation on October 23rd, 2023. Following receipt of proposals from the third solicitation, the OIG's technical evaluation panel scored the proposals and the OIG's contracting officer engaged in negotiations. The OIG awarded a letter contract to Arnold and Porter on January 11th, 2024. The not to exceed amount for this labor hour contract was $749,600. Independent counsel contract administration. Our administration of the contract was limited to ensuring the independent counsel's deliverables were within scope and schedule. To maintain the integrity and impartiality of the independent counsel's work while administering the contract, the OIG neither directed specific investigative activity nor was privy to the documentary or testimonial evidence collected. Transmittal of the independent counsel's report. On May 10th, 2024, we transmitted the independent counsel's report with its findings and recommendations to the mayor and the council in fulfillment of the legislation. Given the subject matter presented, the OIG delivered the report in hard copy and requested that the recipients maintain the report's confidentiality. In conclusion, Chairperson Nadeau and members of the committee, my office's participation pursuant to the legislation was strictly limited to contract award and administration, as well as funding the contract from the OIG's FY 24 Budget Authority. The independent counsel's report, which stands on its own, is there for the district to consider possible improvements to the sexual harassment complaint and investigation process. This concludes my testimony. I am available to answer your questions.
Thank you very much. I think the Arnold and Porter report did a very good job on the issues it examined, but I'm a bit puzzled on the issues it did not examine. The report made some passing observations about issues of workplace culture, particularly within DEMPED, but it did not seem to delve into workplace culture issues that provided a backdrop for the deputy mayor to engage in sexual harassment of subordinate employees. And the report also did not describe any aspects of workplace culture within the executive office of the mayor, where Mr. Falchecchio also held a position of power, or the district government generally. So as a council member, I'm left in an uncomfortable position of still not really knowing if our workplaces, including the ones in this building, are free from sexual harassment or other forms of toxic behavior. But what I want to ask you is, are you satisfied that this report provides an appropriate basis on which to draw conclusions about workplace culture within the district government or the agencies where Mr. Falchecchio had worked?
While the independent counsel didn't do a complete workplace cultural assessment, I believe that the evidence they did collect and report is enough to give counsel an idea of what was going on in both offices.
And how would you describe what was going on in both offices?
How would I describe it? As Arnold and Porter described it. Mr. Falchecchio used the office as an opportunity to date those that were in his supervision.
This one's just for my benefit as a legislator. When the emergency legislation called for an examination of workplace culture, was it your understanding that the scope should be limited to DEMPED, or do you interpret the legislation to apply more broadly?
I would think that it would apply more broadly because he oversaw two offices.
Mm-hmm.
But it's my understanding DEMPED had more employees while the chief of staff's office did not.
Mm-hmm. I asked you earlier if you would share to whom criminal referral had been made, and you said you prefer not to. Are you prevented from saying that now, or is that just a preference?
That's a policy. Where there's criminal investigation activity, I simply don't talk about that
Uh-huh.
for fear of undermining that investigative work.
Okay, so your concern is if you say this law enforcement entity is investigating, that could what, tip him off or,
Correct.
okay.
Correct.
And what we don't want is for him to have a further advantage than he
Right.
already has, okay, with those
Right.
devices, et cetera.
As a law enforcement authority, I never want to undermine another law enforcement authority's work. And by disclosing certain information, does that.
In your experience, once you make a referral, how long does it take for it to become apparent that an investigation is underway?
That all depends on the referral and the agency involved.
Once you make a referral, do your fellow law enforcement agencies let you know whether or not they are pursuing?
No.
So you
I
may
have no
find out,
expectation.
you may find out when the public finds out.
Correct.
Okay. I don't have any further questions. Is there anything you'd like to add?
No, just a point of clarification on the earlier discussion around turning over of documents. What the public needs to understand is there's a process for that. Just because an entity, an agency, or an individual requests something doesn't necessarily mean all that's requested will be turned over, which is why we undergo a particular process to determine what can be turned over. So it's misleading to tell the public that just because someone asks for something, that entities unilaterally give another entity those documents. Just as Ms. Natali said earlier, we have to protect the sanctity of our work as well as the work of other law enforcement organizations, which is why we just don't simply turn things over.
Thank you for that clarification. And I want to thank everybody for your participation today, both in person and virtually. This is a very important topic, not only for those directly impacted, but for everyone in district government. So I appreciate your willingness to come here and talk with us about this report and the process that this government followed, and also recommendations for the future.
Thank you, Councilor.
Thank you very much. This concludes today's hearing. The time is now 12:49 and we are adjourned.
Shopify's point of sale system helps you sell at every stage of your business. Need a fast and secure way to take payments in person? We've got you covered. How about card readers you can rely on anywhere you sell?
Thanks. Have a good one.
Yep, that too. Want one place to manage all your online and in-person sales? That's kind of our thing. Wherever you sell, businesses that grow with Shopify. Sign up for your $1 a month trial at shopify.com/YouTube audio. Shopify.com/YouTube audio.
Hey everyone, welcome to the Simply Learn's full course video on Google Cloud Platform. In this video, we will learn everything about GCP in detail. We will begin this full course video with what GCP is, then we will look into GCP and its concepts in detail, then our expert will give you a quick training on Azure services, then we will see what's the differences between AWS and GCP, next we'll see what GCP web hosting is, after that we will be looking into Google Cloud Machine Learning, and finally we will conclude this video by discussing the Google Cloud Platform Fundamentals Certification Training. By the end of this video, I can assure you that your GCP queries would have been GCP and its concepts in detail. Let's start with an exciting video on Google Cloud Provider. Before we begin, make sure to subscribe to our YouTube channel and hit that bell icon to never miss an update from Simply Learn.
Good morning and good evening, everyone. So welcome to this session on Google Cloud Platform. My name is AJ and I'm an instructor with Simply Learn and also working as a big data and cloud architect for various clients across globe. In this session, we learn about Google Cloud Platform, wherein we will learn about what is cloud computing, why Google Cloud Platform, what is GCP, that is Google Cloud Platform, Google Cloud Platform domains, about a use case, that is Ferrero use case, and also a quick demo on using services from Google Cloud Platform. So when we talk about Google Cloud Platform, we also need to know what is cloud computing. So cloud computing is the use of hardware and software components to deliver a service to a network. Users can access these files and applications and services provided by a cloud provider from any device that has access to internet. In short, cloud computing is a way where cloud provider provides access to different services such as resources. And when we talk about resources here, we talk about computing, we talk about memory, we talk about processing power, we talk about storage, and we also talk about different services which cloud providers make available for the users. Now, that allows us for automatic software integration, backup and restoring data, unlimited storage capacity, having a reliable use of different services, and having a cost efficient solution. Now, we know that cloud computing's models, there are different service models. So you have platform as a service, you have infrastructure as a service, and you have software as a service. And these are the prominent models which are offered by different cloud providers such as Google Cloud, such as Google, you have Amazon, you have Azure, and also some organizations build their own private clouds using open source OpenStack. Let's focus more on Google Cloud Platform and what it has to offer and how it is gaining popularity in the market with different organizations which would want to work on a cloud platform or which would want to work on an infrastructure which is modernized. So when we talk about cloud computing, this is one of the approach which organizations can take to instantaneously benefit from modernization using different services, different platforms, and also newer technologies for their various requirements such as scalability or dynamic businesses. Before we get into Google Cloud Platform, it is also good to understand where you can find some useful resources about Google Cloud Platform. And here you have a website which is from your Google Cloud. So this is cloudacademy.com/library/Google. And here you can create a free account. Now that would give you just 7 days trial, but that has a lot of videos which talk about your Google Cloud Platform and essentials, and it has various certification related videos which you can access. And then after 7 days, after you have tried, you can obviously go for a paid account where you can take detailed learning from here. Now, this is your training library, which shows your different cloud providers such as Amazon, Microsoft Azure, GCP, and then you have various other topics which are specifics to organization. You can obviously look at the pricing, and you can also look at resources which will give you a good experience in learning from these videos. You can also create a free account, which I will walk you through later. So you can create a free account on cloud.google.com. Now, when I say free account, that basically means it allows you to create an account, and every user who creates an account gets a $300 free credit, which can be used to practice, brush up your skills, and also explore and learn about different Google Cloud products which are offered by Google. Now, coming back to our Google Cloud Platform, let's understand why Google Cloud Platform.
What is it?
It's some kind of message.
I don't get it. Who would demand such a thing?
It's the client.
My vendors need a wake-up call, and I'm the one that's going to give it to them.
You also get on a call.
Sure, this afternoon works.
He wants to meet now.
I've got changes.
But you approved everything last week.
Oops.
A client is ruining efficiency and profitability everywhere.
The client says we never sent him the password to the file.
He's literally responding to the email that I gave it to him in, bolded and highlighted.
Why does account management cost this much?
That's just.
I want a full breakdown of what everyone is doing.
But.
What's the issue? I'm sure you're tracking your time. You say good, fast, cheap, pick two? Well, I want all three.
How do we resource this? How do we make money? How do we stop the client?
He doesn't need to be stopped. He needs to be managed.
Who said that?
It's not who I am. It's the tools I use.
Who are you?
I'm Dave from Teamwork.com, the only platform that helps you manage your client work profitably. It makes clients, like the client, less clienty. Here, use it.
He says he didn't show the CEO the project until now. They've got changes. And he wants to hop on another call.
So Google Cloud Platform is popular for many reasons. Now let us see a few of most important reasons why it stands out. When you talk about pricing, pricing is one of the significant factors that make Google Cloud stand out among the other cloud providers. It offers a monthly pricing plan, which is billed according to monthly usage. And when we talk about billing here, the billing can be in hours, it can be in minutes, and it can also be in seconds. There are different options when you talk about your pricing, which can be found from your Google Cloud webpage. Now, pricing could be based on preemptive machines. Pricing could be based on reserved instances or reserved resources. I'll show you the link where you can find more details on pricing part of it. So Google Cloud really has various pricing options which help customers in their different requirements, whether they would go for any of the service models such as infrastructure as a service, platform as a service, or even software as a service. One more attractive thing about Google Cloud pricing is that it provides committed use discounts. For example, under this scheme, you can purchase a specific amount of virtual CPU cores and memory for up to 57% discount off regular prices if you commit usage for either 1 or 3 years. Now, this is just one option. There are various such options which you can learn about from the Google Cloud's page, and that really suits different customers for their different requirements. Now, when we talk about speed, we don't need to really challenge this aspect when it comes to Google services. So Google provides its Google Cloud and Google App customer speed up to 10 terabytes because of its faster cable system. There are different kind of machines which can be used if you're talking about computation, if you're talking about memory hungry applications, or even storage intensive workloads. All in all, speed is one of the defining characteristics of Google Cloud services. The cable has connections over US West Coast, main cities in Japan, and even major hubs in Asia. This speed enhances performances and leads to customer satisfaction. Now, when we talk about customers, any or every customer would prefer to have low latency, high throughput based services. They would want to use higher speeds to process their data in as less time as possible. Google provides a low latency network infrastructure. In fact, you can say that when you are using Google Cloud services, you are using the services from the same infrastructure which Google uses for its popular services such as Google Search or even YouTube, which is one of the second largest repository which can be accessed for videos. Now, when we talk about big data is data which is very complex, has a lot of other characteristics such as your volume, you have velocity, you have variety, you have veracity, validity, volatility, virality, and so on. So if an organization is working on big data, Google Cloud can be a better choice because Google has many innovative tools for cloud warehousing, for example, such as BigQuery, and even real-time data processing tools such as Dataflow. BigQuery is a data warehouse that allows massive processing of data at high speeds, basically working on your structured data. Google also has launched some new machine learning from artificial intelligence tools. Now, there are various other services which we can use from Google Cloud Platform. But let's understand what is Google Cloud Platform and what are some of the services. Even the services which are not listed here can be found in your console from Google Cloud. So what is Google Cloud Platform? GCP. It is a set of cloud computing services provided by Google that runs on the same infrastructure, as I mentioned, that Google uses for its end user products like YouTube, Gmail, and even Google Search. The various set of services offered by Google Cloud Platform are, so you have services which are specific to computing requirements. And again, in computing, you have various different options available. You have machines which are compute optimized, machines which are memory optimized, machines which are storage optimized, and also we have certain machines such as preemptive, which basically means that you could get a machine to work on at a far lesser price than any other machine. But when we talk about preemptive, these are the machines which can be requested on demand and they can be taken back by Google at any time. You have networking related services, which can be very useful when you are setting up your applications or your services across globe. You also have different services which are specific to machine learning, and organizations which would be interested in working on machine learning or artificial intelligence would be really interested in using these services. There are also innovative solutions to work on big data and big data related technologies. Now, when we talk about Google Cloud Platform domains, so we can break down these services into specifics, such as you have compute. Now, the compute service allows for computing and hosting the cloud. Now, when you talk about computing, here there are different services such as App Engine, you have Compute Engine, you have Kubernetes, you have Cloud Functions, and Cloud Run. When you talk about storage and database, so the storage and database service allows application to store media files, backups, or other file-like objects. Now, various services under this are as follows. You have cloud storage, Cloud SQL, Cloud Bigtable for unstructured data. You have Cloud Spanner, Cloud Data Store, Persistent Disks, and Cloud Memory Store. When we talk about networking, the networking service allows us to load balance traffic across resources. Now, as I mentioned earlier, resources could be your different resources which you would be using from a cloud platform, such as your devices, your instances, memory optimized or CPU optimized instances, or other resources, creating DNS records, and much more. So various services under this are VPC, that stands for Virtual Private Cloud. You have Cloud Load Balancing, Cloud Armor, Cloud CDN. You have Cloud Interconnect, DNS, and Network Service tiers. When we talk about the big data service, this allows us to process and query big data in cloud. Now, various services under these are as follows. You have BigQuery, Cloud, Cloud Data Proc, Cloud Composer, Cloud Data Lab, Cloud Data Prep, Cloud PubSub, which is publish and subscribing system. You have Cloud Data Studio. Now, you also have the developer tools, and developer tools service includes tools related to development of an application. Now, various services under these are as follows. That is, you have Cloud SDK, Software Development Kit, you have Deployment Manager, Cloud Source Repositories, and Cloud Test Lab. When we talk about identity and security, which is one of the primary concerns for any organization or any user who would be interested in using a cloud platform, Google Cloud really has taken care of this. So when you talk about identity and security domain, this deals with security services. Now, various services here are cloud identity. You have identity and access management, that is cloud IAM. You have identity aware proxies. You have cloud data loss prevention API, security key enforcement, key management service, and many more. You also have cloud services which are related to Internet of Things. So very much would be used by organizations who would be working on IoT devices or the data generated by these devices. So various services here are Cloud IoT Core, you have Edge TPU, and Cloud IoT. Also, when we talk about cloud AI, that is artificial intelligence, this comprises of services related to machine learning and much more. So you have Cloud Auto ML, Cloud TPU, Cloud Machine Learning Engine, Job Discovery, Dialogflow Enterprise, Natural Language Cloud, Text to Speech, and much more. If you would be interested in services related to API platform, then there are different services under this category or this domain. So you have Maps platform, you have APG API platform, monetization, developer portal, analytics, that is API analytics, APG Sense, cloud endpoints, and service infrastructure. So these are some of the listing of services under each cloud platform domain.
Vector marketing. Some people call it a scam. Some people say it's the best job they've ever had. USA Today calls it one of the top 20 best companies to work for in North America. Sales isn't for everybody. Is it for you? Visit thevectorimpact.com to learn more.
Now let's look at Ferrero use case, and let's also understand what was done here. So Ferrero is one of the famous chocolate and ranks third among worldwide chocolate and confectionery producers. It was found in 1946 in Italy. I'm sure you would have seen the Ferrero chocolates when you would have gone out to buy some chocolates. So the challenges here was that Ferrero, as we know, is sold in every supermarket and is known for its quality. Once the business grew, some issues arose, right? And that's what happens when the business grows. You have issues popping up, which could be related to the volume of data, the speed with which the data is getting generated, the variety of data, and also looking at your platforms which support different dynamic applications or your scalability requirements, performance requirements, and so on. So it needed data storage, processing, and analysis system for a wide customer database. There was a huge gap between the company and the people who bought its goods because the company relied on data given sales outlets. Now that's one of the challenge. Ferrero wanted to create a digital ecosystem where there was a point of contact with its customers and also a foundation for an innovative data-driven marketing strategy. What was the solution here? So one of the service of cloud platforms or Google Cloud Platform is BigQuery. And this was an answer to Ferrero's challenges since it was capable of hyper-fast and efficient data analysis as a solution. Now, as I mentioned, BigQuery is a data warehouse which allows you to store structured data. Now, this could directly be used as a service where you could store in any amount of data and you would not be paying for storage. So there are different pricing models, and for data up to 1 terabytes, you would not be charged anything. And if you would be accessing the data, that is reading the data or processing the data from BigQuery, that's where the pricing model kicks in. Now, using Google Cloud's BigQuery, business analysts of Ferrero were able to store and analyze massive data sets in a very reliable, fast, and affordable manner. Consumer behavior and sales pattern data reports were easy to build and automate. And the analysis also followed Ferrero to adopt advertising across various marketing channels to serve the customer needs in a better way. What was the result? They could divide their database into real-time, actionable consumer clusters to generate more accurate user profiles. Ferrero was also able to personalize its marketing strategies to match the user needs. Now, Google Cloud Platform completely tailored the website, mobile content, and advertising, and created a very cost-effective media buy strategy. Now, these were some basics on Google Cloud. Now, as I said, you can always find a lot of details about pricing, about services, and also all the services are accessible in your free trial account. Now, let me just walk you through here. So one is you could always find details on documentation on each of these services. So if I would click on getting started, you have quick start, which basically shows you short tutorials. You have trainings and you have also certifications. Now, if we click on quick start, now that takes me to this page, which shows me quick starts, or if you would want to understand about different projects, if you would want to look into the documentation of creating a Linux virtual machine or storing a file and sharing it, deploying a container, Docker container image, and so on. So you have a lot of quick starts here. You can also look at Cloud Minute. On the same page, on the right side, you have docs. And once you click on that, it takes you to these links. Now this shows you build solutions, which shows you top use cases, best practices, all the solutions. It's always good to learn from these use cases which are available. And here you have different featured products and all the different services which Google Cloud offers. Now you can click on featured products, and that basically shows you a list of these products. Now here we have all the solutions which you can look at: architecture, database, enterprise level, big data and analysis, gaming related, Internet of Things, and so on. Now, if you go down here, it shows you featured products, and that shows you some of the important products such as Compute Engine, which is belonging to the compute domain. You have Cloud Run, you have Anthos, which is for migration and basically cloud adoption. When organizations would want to move from on-premise to cloud-based solutions, you have Vision AI, you have cloud storage. Now that basically allows you to store any kind of data, whether that's an object. So this is acting as an object storage. You have Cloud SQL, which is basically a ready-to-use service where you would be using MySQL, Postgres, or any other SQL Server database services. You have BigQuery, which is a data warehouse, which basically allows you to store your structured data. And then you have your AI and machine learning related products. So you have AutoML, Vision AI, Video AI, text to speech, speech to text, and so on. Now you also have different platform accelerators which can be used. And in any of these cases, for example, if I would click on Compute Engine, which is a featured product from Google Cloud, now that shows you basically your quick starts using your Linux machines, how-to guides, which tells you completely working on a VM instance or working on storage, working on persistent disks, and so on. And it shows you the documentation here. Now you also have products and pricing option, which you can see for GCP pricing. And you could straight away go to the pricing. You could be looking at solutions, which talks about infrastructure modernization. Now, this is something which organizations are interested in when they would want to move from their on-premise solution to your Google Cloud. Now, here I can say, for example, I click on infrastructure modernization. You can always find some case studies. What are the different solutions we have here, right? When you talk about Google Cloud, so you can always click on see solutions, and you can look at VM migration or SAP Cloud, right? Why Google Cloud, what it can be used for, VMware as a service, or HPC, that is high performance computing. And about these services, we will learn in detail later. Now I can go back on the same page where I was clicking on the services. So you have quick starts, you have how to guides, you have deep understanding of different concepts, right? And here, if I click on all how-to guides, so that shows me what are the different ways in which you can work with compute engine and working with different instances. Although it's quite exhaustive content, but then if you follow steadily, then you can learn a lot about Google Cloud. Now here, I can just go back. So this is just giving you some idea on the different products which are available from Google Cloud, looking into different sections, finding right documentation here, right? And you can always look into each one of these in detail for each product which Google Cloud offers. Now, if we scroll down, we could see all the options or all the domains which we see here, right? Let me just go back.
Hundreds of records to update. How on earth are you going to do that?
Well, I have...
One by one, of course. Oh, that was easy. Hey, wait, you're leaving. What about that dashboard?
Zia, show me a dashboard of leads from the past month.
Hey, what about the...
Who said CRMs can't be easy, huh?
Experience simplicity with Zoho CRM.
Have you had your Hershey's?
Because we got into solutions, now we have quick starts, right? And then you can basically scroll all the way down to look at Cloud SDK, which can be set up on your Windows machine, like I have set it up on my Windows machine. Plus, when you use Google Console, you have a GUI, which I'll show you in a couple of minutes, and also a Cloud Shell where you can use your command line options to work with Google Cloud Platform. You have Cloud Console, which is nothing but your GUI to access your resources. Now you can also look at in-depth tutorials, pricing, and you have different other options. So let's just click on pricing here. And then we have your price list, which basically gives you details of different services, what are available, and what are the services or what are the prices. So for example, if I click on Compute Engine, right, and this shows me the pricing aspect of Compute Engine, which belongs to Compute Domain. And here you can see you have VM instance pricing, you have networking pricing, sole tenant nodes, which are specific to particular organizations. Or if organizations would want to have dedicated nodes, you have GPU based pricing, right? So general processing units, you have disk and image pricing, and you can click on any of the links and you can see pricing, which also shows you your different kind of machine types. So here you have different kind of machine types, which says N1, N2, N2D, E2. You have memory optimized machine types, you have compute optimized, you have premium images, and you can basically look at all the categories. You can look at disk pricing, which involves your persistent disk pricing for SSDs or HDDs. What are the kind of images? What are the different network services, right? And you can always look at your machine types. You can choose a particular region, right? There is the concept of region and availability zones here. And as per region, you could look at the prices. You can also look at standard prices. You could be looking for what are the free tier machines. If I'm specifically looking for VM instance pricing, I can click on this one, and that takes me to the VM instance pricing. What is the billing module? What is the instance uptime? What is the resource-based pricing? And then you can also look at different kind of discounts, such as sustained use discounts, committed use discounts, discounts for preemptible VM instances, and so on. And this is how you can be looking at pricing for all different resources. And you can choose the resource which you are interested in, and then look for the pricing, benchmarks, reservations if you would want to use and you would want to benefit, if you would want to look at what are the quotas and limits, and so on. So please explore this link and you can find a lot of information when it comes to technical options, looking at different Google Cloud products, which we briefly discussed when it comes to domains and what each product can be used for. you can always come back to the main page where I was showing you different services. We went into pricing straight away, right? Now you can always come back to this page on your cloud.google.com, and then you have your solutions, which talks about different products, right? And you can click on these, or you can look into technical documentation. So this talks about your different featured solutions, infrastructure solutions, you have data center migration related, and so on. So I could be talking more and more about Google Cloud Platform. It's a ocean, it's a huge chunk of different services for different organizational requirements. So look into this link. And also what you can do is create a account on Gmail. I mean, you could create a free account, or you could go to cloud.google.com and then you could create a free account like I have created here, and I can just click on console. Now that's my GUI, or Google Cloud Console, which basically allows me to work with Google Cloud. Now there are a lot of options here. By default, when you create an account, now in my case, on the top it says it's a free trial account. I have $300 credit, and out of that $251 is left, and 237 days out of a year are left for my account. Now here I can basically see the project, right? And by default we can create a project, or by default there is a project existing for any user. So when you log in, it creates a particular project, and you could create a new project, and project would be to dedicate your different services or different resources per different project. So this is your dashboard, which basically shows your project, which shows you a project number and a project ID, which is always unique. Now you can click on this, and this, if you would want, you can hide this information. You can also look into the documentation part of it. Then it shows you the different services, or a graphical information of services which you might have used in past. So you have compute engine, which shows you how much percentage of CPU was used. You can always go to compute engine as a service. You can look at your Google Cloud Platform status and look at the Google Cloud status. Now this is billing. Now since this shows me the billing period for April month, and I can always look at detailed charges. I can look at reporting. I can look at different APIs which Google offers. And for your different kind of work, you can always go to the API overview or the API link and enable or disable any API. Now, once you enable or disable any API, then you can use that. So you have news section, you have documentation, and you have getting started guides, which tells you how to work or enable different APIs. If you would want to deploy a pre-built solution, add dynamic logging, monitoring errors, deploying a Hello World app, and so on. Now this is your dashboard. I can click on activity, and that would show me what kind of activity I would have done in my cloud platform. I can always choose the kind of activities by saying activity type. I can choose the resources. Now it shows me that I created some VM instances, I deleted them, I updated some metadata, I basically worked on instances, I changed some firewall rules here. I have then also worked on some other services or APIs. So I created some buckets, which is for object storage. And again, I have been working with some instances and creating some firewall rules. Here, I have granted some permissions. I am setting up a policy, right? So this activity gives me a history of what things I have done over the past couple of months while working on Google Cloud Platform. Now, on the top left corner, you have the hamburger menu, which you can click on this. So that's your navigation menu. And when you click on this, this shows you home. It takes you to the marketplace. It specifically takes you to billing. You can always look at APIs and services. So here in API services, I can pretty much go to a dashboard and I can see a report on the traffic or errors or latency and the kind of APIs which are available. So you have Compute Engine API, you have BigQuery API, BigQuery Data Transfer API, BigQuery Storage, Cloud Data Proc. So these are some of the APIs or services I've used in past. Might be I was evaluating a product, might be I was using a particular product. So you have whenever you would want to use a particular service from Google Cloud Platform, you would be enabling these APIs. So here we see some APIs for data proc. You have logging, monitoring, you have resource manager API, you have cloud SQL, which allows you to directly use MySQL or Postgres, you have cloud storage, right? And so many APIs. So if I would want to enable a particular API, which is not right now required, but then it's good to know, you can always click on this one. You can search for an API. So for example, if I would say data proc.
Just because a hotel says it's dog friendly doesn't mean a dog will find it very friendly. Get an Airbnb that's friendly for everyone.
AG1 works by making foundational nutrition easier. Combining vitamins, probiotics, and whole food source nutrients into one comprehensive formula. Start simplifying your nutrition today at drinkag1.com.
Right? And that shows me the Cloud Data Proc API, which manages Hadoop-based clusters and jobs on Google Cloud Platform. So I can spin up a Hadoop cluster and I can start running some jobs on a Hadoop cluster on demand. And as I'm done with it, I can just get rid of it. So this is an API which I would have to enable. And then for every particular service, you also have an admin API, which you would enable. Now, going back, so coming out from this API library, I got into API and services. Now you can look into the library, you can look at credentials, and you can also look at different time intervals for which you can see the usage of your different APIs. Now, going back to the menu, you have support, wherein you can always reach out to the Google support team if you are using a paid version. Even with free trial, you can try to reach out and you will find someone to help, but it is always good when you have a billing cycle, reaching out the customer care. You have identity access management and admin, and this is required when you're working with different APIs or services, when you would want to have relevant access. You have getting started, you have security related options, you have Anthos, which is mainly for migration. Now here you can look at your different domains, such as which we discussed. So you have compute, and in compute you have different services. So you have App Engine, you have Compute Engine, Kubernetes, you have Cloud Functions and Cloud Run. You can look into the storage aspect, which shows you Bigtable, which is usually and mainly for your unstructured data. Bigtable, which is something which gave rise to popular NoSQL databases like HBase and Cassandra. You have Data Store, which can be used. You have Firestore, File Store, Storage, which can be used to put in data of any kinds. You have SQL for structured data. You have Spanner as a service. You have Memory Store, and you have Data Transfer. Now, when it comes to the networking domain, you have all these services such as VPC, Virtual Private Network, network related services for your load balancing, for using a cloud-based DNS or cloud-defined network. You have hybrid connectivity, network service tiers, security, and intelligence. Then you have other options for your operations which can be used. And here you have different other tools which can be used, such as Cloud Build. You have Cloud Tasks, Container Registry, Deployment Manager, and many more. Big data specific, you have the services here. So you have Data Proc, which can be used to spin up your clusters. You have publish subscribe messaging systems such as now Kafka, which you might have heard of, originates its idea from here. So PubSub, you have data flow, you have IoT Core, BigQuery, which is a data warehouse package or data warehousing solution from Google Cloud. Now, then you have your artificial intelligence related services and other Google solutions. So you can always find a huge list of services, or you can say at high level solutions offered by Google Cloud. And we can use these to basically test some of the solutions, use them, and work on them. So I'll give you a quick demo on different services which can be used here from your Google Cloud Platform. Now, this is your Google Cloud Platform, and this is your console. Now, this also gives you a Cloud Shell, which can be activated so that you can work from command line And you can always find a lot of documentation on that. So you can also set up your Cloud Shell, that is SDK, on your Windows machine. And if you have set it up, then basically you could be doing something like gcloud, right? If the cloud has been set up. So in my case, I had set up the Cloud SDK, and basically I can get into that by looking at what path I have set up. So Cloud SDK, and then I can be using it from my Windows machine as per my comfort. I can also activate the Cloud Shell here, which will basically open up a terminal. And at any point of time, you can open up this one Cloud Shell in a different window. It is preparing the Cloud Shell, where it will by default set up your project. It will set up the metadata. And now I am logged into my Google Cloud account from command line, and here I can basically use gcloud, right? And that basically shows you the different options which are available, which you can be using. So if you would want to use a particular service, you can also try giving a help, and that shows you how do you manage your Google Cloud platform, right? So you have different options for billing, to work with your different services, and basically you could be working on Google Cloud using this Cloud Shell from your command line. Usually for people who are learning Google Cloud in the beginning, it is always good to go for console and use your different services from here in an easier way. But as I said, you can always use the command line. For example, if I would just go ahead and type gcloud create instances, and that will directly take me to the Cloud Console documentation, which shows you different options which you can use to work with instances. So I could do a gcloud compute instances create, and then I can give my instance name and so on. And I'll show you some examples on that. So you can be using your Cloud Console, right? That is your Cloud Shell, and you can straight away start working from command line. However, I would suggest using console in the beginning, and when you are well experienced, then you can start using Cloud Shell to do things from command line. And when you are fully experienced, you can always switch, and certain things are usually useful or easier when